Hey, what's up, guys? Welcome to Lawsplaining the Interwebs. I am your host, Nick Rekieta. I am a lawyer in central Minnesota. I own my own law firm that is Rekieta Law. If you're ever in Minnesota and you run into any legal trouble, please look me up. I'd be happy to help out or just provide some friendly advice, as I am a man who likes to help people. So I do apologize for the late start to the stream. And this is no excuse, but I was waiting for my lovely wife, Lady Rackets, to get home because, you know, we do things as a team, sort of. She likes to watch the streams, and she was running just a few minutes behind. So I apologize that has translated to you guys. I take full responsibility. Please feel free to rip me up in the comments or the chat, and I am happy to endure that. First order of business, there was a pre-stream super chat from Garrett Snyder, and it was orange drink in all capital letters. And I agree, orange drink for the win, a necessary component to all legal matters. And, what? Sure. And here, for an in-person mea culpa, is Lady Rackets.
I'm so very sorry. I didn't mean to be late. I was rushing, and
they'll probably forgive you before they forgive me. So anyway, so what we have today is a couple different things. We are going to learn how to lose a DUI, DWI, OWI case. We are going to learn how to lose a case in court, and we're going to do it with an example. We're going to start right with the incident report from pulling over the automobile, and we're going to go through some of the legal arguments and the problems with them as they go. And this is a little bit different kind of stream. I'm hoping for a lot of interactivity. So let me cover how you interact with me. There are two easy ways. One is that you do a super chat, and the super chats do cost money, and I respect that very much. If you do a super chat, it will pop up in giant letters on my screen and alert me to it. I will be happy to read the super chat on the air, and I will also address any question that may be in there. The other way is, as Goss Demon has demonstrated, by tagging me in the chat, which I will be attempting to follow to the best of my ability. And if you tag me in there, I will try to get to your question, but it really does depend on just how many questions I get, and keep trying to keep a flow to this sort of thing. So there is that. Either way is fine. I do not require anyone to send money to interact with me, but it does help me see your question easier, and it's very much appreciated. I very much am happy when people do that, and I know that money is not free, and so believe me, very much appreciate that. Hatbuckles asks, what am I drinking tonight? And that is the next order of business right after this. Kevin Cartilage says, donating to the Lafrague Fund. Yes, I need to find a good bottle of Lafrague, and I have good news. I am going to the Twin Cities very soon, and so I will have an opportunity to go to a bigger liquor store than what's around here and hopefully get a nice bottle of Lafrague. Not a Lafrague 10 is great, but I'm hoping for something a little bit classier. But I was given by a good friend, Keck7Go. You'll see him in some of the chats. Hopefully he'll pop in tonight. He sent me some Finnish whiskey. This is Jury unaged single malt rye, and I am really excited to try that. Totally not Asterios Kokonos says, how long is today's episode? Buddy, I have no idea. Kev the lawyer, get off my tail already. Sorry, man. That's not going to happen. All right, so this is unaged. If you don't know, I probably shouldn't talk about distilling whiskey because I actually don't do it or anything. But if you don't know, unaged whiskey, the coloration is clear. And coloration comes from either the barrel that you're using or an artificial coloring. Many, many scotches and whiskeys use artificial coloring. Some people have problems with that. Others do not. But this is an unaged whiskey. I expect it will be a little harsher than the other stuff I'm drinking. It has a very grainy smell to it. I mean, it smells like, I don't know, almost like a bowl of oatmeal. Wow. It is very strong, but it's good. It's got a surprising kick to it. Like I said, the rye is extremely strong, comes right through. There's no woody flavor to it. So it's great. So Keck7 Go says, close enough on the pronunciation. Double U means longer U. So jury, is that better? You can run your car off that stuff. I think so. But it is good. It's very much appreciated. It's very different than the other whiskeys I have. And, I love to explore things. How many DUIs would it take to lose your license to practice law? You know, I think DUIs and lawyers are pretty common bedfellows. So I would say quite a bit, unfortunately. Usually the DUI is not in relation to practicing law, but that would change very quickly if you got a DUI maybe on your way to a hearing or something like that. And I do want to address a certain friend of the show in the chat. His name is Calihal NWN2. He is begging people to please buy Asterios Kokkinos' overpriced DVD to help him pay for his lawyer's fees. E-begging on his knees. And I think everyone here should agree that we should help out Asterios Kokkinos in any way possible, because this is an unfair case against him. He doesn't deserve this. Nobody does, but he has less means than Dick Masterson to do that. And he should definitely get your support. Patreon.com/Asterios is a great way to do that. Also, before watching this, I was watching Big Dick Masterson on Twitch doing some Friday night piano streaming, and you guys should definitely check it out if you have not watched his Twitch streams. They're great. They take you right back to the 90s musically, and I really appreciate that. Let's see. Pony Cordero says, Morgan of Morgan & Morgan in Orlando is literally never allowed to drive again. He has so many DUIs. Well, I will say that Landau has some work to do. All right. So let's cover something quickly. I have these out of order because my Adobe crashed while I was doing it, so they got switched. Let's cover something quickly. There is the potential that someone watching this might think that this is an illegal thing that I'm doing, or that there is some sort of civil cause of action for the disclosure of private information. And I would kindly like to inform anyone who may be confused about this that this is absolutely legal. This was determined specifically by the court in 1975 under Cox Broadcasting Corporation versus Cohen. Alan Foster says, I'm literally driving right now. You started the live stream before I could get home. GFY. Sorry, buddy. I held off as long as I could. I even blamed my wife trying to get it to hold off for you. So I expect some sort of thank you for that, because I'm sure I will pay for it later. But, you know, I tried to hold out, but the stream had to start at some point. So Cox Broadcasting, I'm not going to go through this whole case. But the short story is that the father of a deceased rape victim brought action against Broadcasting Company and others to recover damages for invasion of father's rights of privacy, which invasion allegedly occurred when Broadcasting Company, in contravention of a Georgia statute, I cannot speak today, identified the victim during television coverage of the trial of the alleged rapists. The Superior Court, Fulton County, granted father's motion for summary judgment. Long story short, the Supreme Court overturned it. So what happened was Georgia had a law that prevented you from disclosing the victim of particular crimes, violent crimes or sexual crimes. that law was found to be unconstitutional, and we'll talk about why in just a moment. Ketchup pizza, fantastic, perfect, wonderful. Unicorn-shaped building, just wait for the restraining order. We'll shut down your entire channel for your crimes against Google and reputable lawyers. I can't wait. I cannot wait for a restraining order. And yes, we are dogpiling on you, Kev the lawyer. I apologize. Herb Beta Patch says in New York, one felony conviction is enough to disbar under Judiciary Rule 94A. The conviction can be from any state. I will point out that neither of the DUIs of Kevin Landau are felony convictions. They are both misdemeanors under the law. They're both statutes. So, you know, that's how it goes. These are not felonies. So I'm not familiar with the New York judiciary rule, but I'll look it up after the stream and see. I'm wondering if there's some sort of argument that it's only applies to certain felonies or not, but I trust your judgment. Now you just have me curious. Some kind of taco, yo, for my devil, what even is a crime? I don't know anymore. And 3 would be a felony in Michigan, sure. In Minnesota, you can get felony level on your first one, depending on if you have aggravating factors like a kid in the car, if you're over double the legal limit and stuff like that. All right. Arbin Gordon says if they were felonies, could he even practice anymore? It's state specific, so that would be the question. The first thing I would do if Mr. Landau decides to send me a cease and desist or copyright strikes against me would probably be to stream it, frankly. Hatbuckle says, I got arrested taking Vin Diesel's advice and living my life a quarter mile at a time. Can I sue him for $20 million? I think you can sue anybody for $20 million these days. But let's go to this decision in Cox Broadcasting. Here we go. So there's a lot to this case, but here's the relevant section. And I'm going to read through it. For my devil says, so basically the punishment you get is proportional to how fun you are. Yep. Usually that's how it goes. Andre says, hey, Rekieta. Hey, Andre. Oh, and I'm really glad that AIDS Jesus is back in the chat. Sorry for having you muted for so long, buddy. I thought I had unmuted you, but I am incompetent at YouTubing. So anyway. All right. Let's go through this decision here. And this is the main part of the decision that we're curious about. And again, the question in this case is, can you disclose private or I guess public information? Is it protected private information in regards to criminal or court records? So the court says, by placing the information in the public domain on official court records, the state must be presumed to have concluded that the public interest was thereby being served. Public records, by their very nature, are of interest to those concerned with the administration of government, and a public benefit is performed by the reporting of the true contents of the records by the media. I'm the media. Welcome to it. The freedom of the press to publish that information appears to us to be of critical importance to our type of government in which the citizenry is the final judge of the proper conduct of public business. In preserving that form of government, the First and 14th Amendments command nothing less than that the states may not impose sanctions on the publication of truthful information contained in official court records open to public inspection. In summary, if a court record is not sealed, and there are all sorts of ways to seal court records, you can publish it as long as as long as there's some sort of interest of the press. I would argue that in this case, there's plenty of obvious interest in Kevin Landau's criminal record. And we are going to do more shows on Kevin Landau covering official court records that are published and public, just like this stuff. And we will do those. We're gonna do how to avoid sanctions. We're going to talk about how to lose clients' money. We're gonna do all sorts of things like that. And these are all publicly available documents. Some of them do require money to get to, so they're not all easy to get to, but you can go to the individual courthouses and review these documents. So that is covered. Also, one thing I forgot to cover right at the beginning, as this is a Q&A stream about a frequently encountered criminal issue, which is driving under the influence or operating some sort of vehicle while intoxicated, If you send me a question and I answer it, you cannot accept it as legal advice. I am likely not licensed to give you legal advice. My advice is general. My legal advice to anyone who asks a question today is contact an attorney in your state, preferably a specialist who deals with DUIs on a relatively frequent basis. They're going to be a much better source of information. The stuff we're doing today is for information and entertainment purposes, not for the purposes of legal advising. So please do not be confused. Let's make it very clear that I am not part of any defense or prosecution team in these cases, just observing some public documents and relaying that information to you. So, going on with the court, we are reluctant to embark on a course that would make public records generally available to the media but forbid their publication if offensive to the sensibilities of the supposed reasonable man. Am I right to drink after this stream? You should drink during this stream unless you're driving during this stream. Such a rule would make it very difficult for the media to inform citizens about the public business and yet stay within the law. The rule would invite timidity and self-censorship and very likely lead to the suppression of many items that would otherwise be published and that should be made available to the public. At the very least, the First and 14th Amendments will not allow exposing the press to liability for truthfully publishing information released in the publication or to the public in official court records. If there are privacy interests to be protected in judicial proceedings, the states must respond by means which avoid public documentation or other exposure of private information. Their political institutions must weigh the interests in privacy with the interests of the public to know and of the press to publish. Woo! Sorry. So Ketchup Pizza says, not looking for legal advice, but do you blow or not blow on the spot? I've heard both ways. That's a fact specific question. We'll get to that. When we start going through and we get to the point where I'm talking about field tests, remind me if I don't address your question, but I want to address it kind of in line there. Monster Slayer meant to type drive. Are you right to drive after the stream? Not if you're drinking, buddy. Once true information is disclosed in public court documents open to public inspection, the press cannot be sanctioned for publishing it. In this instance, as in others, reliance must rest upon the judgment of those who decide what to publish or broadcast. See Miami Herald Publishing Company versus Tornillo. And then finally, this is related directly to the Cox case, but is relevant here. Appellee has not contended that the name was obtained in an improper fashion or that it was not an official court document open to public inspection. Under these circumstances, the protection of freedom of the press provided by the First and 14th Amendments bars the state of Georgia from making appellant's broadcast the basis of civil liability. So, sorry if anyone is thinking that these types of streams and broadcasts of public documents is grounds for civil liability. They are not. Everything in them is an official court record, and as far as I know, they are true. If they are not true and part of the official court record, we need to start asking what's going on with the courts if they're not able to keep true things in their record. Eric Blum, should I play Diablo 3 while watching this? Yes. Let's see. Some Kind of Taco asks, in what ways can they not disclose information? They cannot disclose information by sealing the record. They do this very frequently, or by redacting the names to initials. They do this very frequently with children involved in various litigation, children involved in, for example, criminal cases, or family law cases. Their names are often reduced to initials so that they cannot be as easily identified. Sometimes entire records are sealed when they involve minors as victims of crimes or minors as perpetrators of certain crimes as well. So sealing documents is something that you need to talk about. And the 212 mentions Chief Justice Berger. That is Chief Justice Warren Berger, Chief Justice of the Supreme Court, and interestingly, a graduate of the law school that I graduated from. So good job. Good job, Chief Justice Berger. Kim Jong Skill, can you get a DUI in smaller vehicles like a lawnmower or golf cart? Probably. They're often, like the Michigan statute is operating while intoxicated. So it really depends on the state statute and how it's worded. But yes, I think that is a common thing. Boats are commonly operated while intoxicated. It really depends on what the definition of a motor vehicle is and how the statute is worded, but possibly. And also if you're on a road, that's another thing. If you're driving a lawnmower on a road, you might want to reconsider your options. And Biggest Dickhead says, so you're saying that since I'm in Michigan, Landwy would be a good lawyer to hire for a DUI since he has so much experience with them. I mean, I don't know. I would really question his ability. For My Devil asked, you wipe standing up or sitting down? Standing up. So then Synthesis says, what do you call a 2,500-pound rooster? Big fowl. Big fowl. Yes. All right. So let's go now into the incident report for this particular case. Now, the incident report is not a court document, and the incident report here is I have redacted all names from this incident report. So I am not revealing the identity of the person involved in this incident report, but it is a good sort of barometer on how these incident reports look and what kind of things police look for when they pull you over. Ashley Princess says, Rekieta Law, you haven't been to Michigan much if you think riding a lawnmower on the road is an abnormal thing. FSP AMSS, wait, operating, could you get a DUI for remotely controlling a vehicle? That's a tougher question. I don't know that answer off the top of my head, but possibly. Reach around. Not sure if you covered this, but why is a lawyer's ability to offer advice or represent someone restricted by state lines? The states all have different rules of procedure. They have different rules of professional responsibility. All of this is controlled state-wise. They have different rules of evidence. Sort of. Most of the rules of evidence are pretty uniform, but they also have just a large amount of law. And I would say that most lawyers cannot be sufficiently trained in every aspect of law within one state. It makes it very difficult when you're going across state lines to be sufficiently proficient in the various requirements of each state. How'd you get the incident report if it's not a court document? Through the police document. This incident report was provided to me by a friend. I'm not entirely sure how they obtained it, although I know it was not illegally obtained or anything like that. I believe it was a Freedom of Information request, but it is not part of the court record, so getting it is a little bit of a different process. But again, I have redacted any names, so there should be no identifying information in here. But we'll see. So this is a 30-year-old white male, and let's the offenses is operating under the influence of alcohol or liquor. Guns, Beer, Freedom 87. Yes, of course it means we're friends. So here we go. This is a person who's driving a 2005 convertible Lexus. This incident occurred, when was this? November 22nd, 2006. This is in Michigan. Let's see. So this is the police narrative, and this is where we start to find out where the, I guess, suspicion comes to making a stop and then an arrest. Sorry for my stuttering. I should drink more whiskey. Wow. I was southbound Orchard Lake Road, just south of Seminary, when a northbound vehicle crossed halfway into the southbound lane, causing me to pull off to the right as far as I could to avoid a collision. All right, so this is step one. This is step one in losing a DUI case, okay? The first step is to be driving a vehicle and to swerve into the other lane when there's an oncoming police cruiser and force the oncoming police cruiser to pull over onto the side of the lane or the shoulder to avoid a head-on collision. That is the first way to start losing your DUI case, is to almost hit a police officer. I would strongly recommend against doing that, but we'll see. So the suspect vehicle... Oh, wait. Sorry. I turned around and caught up to the vehicle just north of Maple Croft. The suspect vehicle continued to go over the center line, then back onto the shoulder of the roadway. I activated my emergency lights and attempted to stop the vehicle. The vehicle continued northbound until pulling over near Millwall in Kego Harbor. Upon my initial contact with the driver, I observed the following. Ketchup Pizza says, Rekieta Law, is there a Patreon tier where Tess sends us nudes? Not on my Patreon. Sorry, I don't distribute nude photos of anyone, nor do I collect nude photos of anyone before anyone gets any ideas. Some kind of taco. How is a dog sups? I have no idea. All right. So yes, the police officer observed the following. The driver's eyes were bloodshot and glassy. A strong odor of intoxicants were coming from him. His speech was slow and slightly slurred. I asked him for his license and registration. So, next step. Don't smell like liquor. Don't slur your speech. And don't have bloodshot and glassy eyes. The lawyer doth protest too much. Could be. Let's see. Yes, so asked him for his license and registration. He began to look through his wallet. If you get pulled over, get your wallet out and have your license and registration ready to go. He then stated that he was an something. That would be a profession. I have redacted the profession just in case anyone would be thinking that that was identifying information. I asked him where he was coming from. He said that he was with a client having a meeting. I asked him where the meeting was. Now, the police officer's use of question marks here is not necessary. He's making statements about what he asked, and grammar is important to this channel. He said they were at Zink's on Orchard Lake Road. I asked him if he had anything to drink tonight. He said that he had a glass of wine and maybe a couple cocktails. Maybe. How long ago did you have your last drink? I asked. Notice he doesn't have a question mark there. He did that one properly. He said about a half hour ago or more. He gave me his license and registration. Driver ID was redacted. Unicorn-shaped building is not hitting police officers your legal advice. Yes, do not ever swing at a police officer. Do not ever attempt to hit them with anything. That is pretty safe legal advice. And if you mean with a vehicle, yeah, don't hit them with a vehicle either. I then asked him to step out of the vehicle and do some tests for me. Redacted exited the vehicle and stood between my vehicle and his on the shoulder of the roadway. The shoulder was relatively flat with no holes. So the officer is establishing that any walking tests are not going to be tainted by unlevel ground or some sort of artifact of the pavement that would cause someone to maybe stumble or fall when they're supposed to stand ready or stand steady. I asked Blank if he had any physical disabilities that would prevent him from doing the tests. He said he was fine. Following is a list of tests given and the results of the same. Each test was explained and demonstrated prior to his execution of the test. Kev the lawyer says, what if a police officer rubs your belly and you hit them by involuntary reflex? That's probably okay at that point because I believe once they start rubbing your belly, a return touch is consensual, but you should always get affirmative consent. Why is vehicle abbreviated? Just because police officers have to write a lot of these incident reports and it's easier to abbreviate commonly used words. That's my guess. I guess I don't know for sure, but that's why I would do it. So here are the following tests. ABCs, very slow. So he requested him to say the ABCs. He said very slow, but all letters were given in order. Good job. The officer is the Mark Twain of cops. 2, he had to count backwards from 95 to 75. He said slow, but the counting was correct. 3, Romberg. Showed some swang, held for 35 seconds when I said 20 seconds. I don't know what the Romberg test actually is because I have no idea. So I apologize. I could look that up. Or if someone in the chat wants to look up real quick what the Romberg test is specifically. I failed in my lawyerly duties of researching that one ahead of time. 1 leg stand. So he asked to stand him on leg, and he said that he could not hold the stand for more than 5 seconds without dropping a foot. 1 leg swing, could not perform more than 1 swing at a time without dropping foot and a bent knee. Heel to toe walk, 7-5 means 7 steps out, 5 steps back. He had a staggered walk. He did not touch, which means he did not touch heel to toe, and he took 7 steps out and 7 steps back as opposed to 7 and 5. So then he administered a portable breathalyzer test, and that result was 0.125. The legal limit in Michigan at the time of this pullover was 0.08. Okay, Kenster1790, thanks for looking that up. Ask the patient to stand with their feet together, touching each other. Ask the patient to close their eyes, remain close at hand in case the patient begins to sway or fall. Okay, so yeah, basically close your eyes and stand still test with your feet together. This is difficult to do when you're intoxicated. Huge Penis says, do you recommend doing the field sobriety test if you were pulled over, whether sober or not? Man, it's a tough one. Typically, I would advise against taking any tests or consenting to any search. You'll have to check state-specific regulations on refusing field tests. In Minnesota, for example, you are allowed to refuse a field test, but refusal of a field test immediately grants the officer probable cause to effect an arrest and to impound your vehicle if there's no sufficient driver. So if you refuse that field test, they can arrest you, and that is probable cause to take you into the station and administer the intoxilizer test or a blood alcohol test, either through breath, blood, or urine in Minnesota. And if you refuse that test, you automatically are convicted of a felony, and I cannot advise anyone to do that. But yeah, it's really going to be state specific as for whether or not you're allowed. You should refuse a field test. In Minnesota, it's a tough call. It's a tough call. It really probably depends on how much you've had to drink, when you were drinking. If you're sober, refusing the field test can be beneficial, but that's a really fact-specific question. Same in Michigan, you'll just get taken in for a blood test for a field refusal, I believe, says Goss Demon. And that's probably pretty standard across states, but you have to weigh out what you want to do, what your evening looks like. I mean, if you're sober, it may be beneficial for you to take the test and just get on with your day. But I always have a problem automatically saying anyone should accept what a police officer is asking them to do. So based on the interview and the test results, I placed Redacted under arrest for operating while intoxicated. Redacted was placed in my vehicle after a pat-down search. Sergeant Roy handled the impound of, well, there we go, Kevin's vehicle. I forgot to redact. I transported to WBT, where I read him his chemical test rights and asked him to take a breath test. He said he would. What? Oh, good night, baby. I asked him to take a breath test. He said he would. I performed the breath test and obtained results of 0.15 and 0.15. Redacted. We're going to stick with redacted. Was processed and lodged for 7 hours. Citation issued for operating while intoxicated. Court date of 11/29/06 at 8:30 a.m. LEIN input of breath test and issued temporary license. Closed by arrest. So. So anyway, I redacted this like just out of, politeness, but whatever. I think the joke is missed by my failure of one Kevin. One Kevin has failed. For Guns Beer Freedom, thanks for the donation for my public display of fatherly love. So this is Kevin Bacon's arrest report, right? Yeah, I think so. That's one $20 million lawsuit. Is this Kevin Landwy? Ask Dax Desi. I don't know. You'll just have to figure that one out for yourself. Redacted Law Dog isn't as cool. So yes, here are the test results from the breath test that was actually applied at the station. Jaeger Mitchell, thank you for the donation. Synthesis, was that another new baby? That is my newest baby. That is the 5th baby that we have. My older ones, of course, are no longer babies, but that is our most recent. So there we go. So here we have the test results. And if you look up here, it's blood alcohol content of 0.15 and 0.15. So almost twice the legal limit, but not quite twice the legal limit. The instrument number is here. They actually have the arresting officer's name and the person who administered the test. I did redact those. I didn't think they needed to be dragged into any of this. The officer didn't put enough apostrophes in Kevin's name. I think that's true. In America, every 18 seconds, Rekieta Law has another baby. Oh my goodness. In your opinion, can Landui count back from 95 to 75? He seemed to perform the test, in my opinion, without missing any numbers, although slowly. Is Maddox better than your children? No, obviously not. He's actually, the funny thing is Maddox is not better than many children at many things. You know, one is being cute and likable. So, yeah, so his Michigan driver's license was confiscated and destroyed. He was not under 21. Driving status on the date of the arrest, he was valid to drive at the time of this arrest. And then here's just another copy of the exact same document. And here's his receipt for the blood alcohol tests. These blank tests are done to the machines to show that they are zeroed out. Basically, like if you remember your high school chemistry classes or whatever, you would you're weighing anything, you would tear out the machine to make sure that it was zeroed out before you did any measurements. That's what the blank tests do. So they do a blank test, they do a sample of 0.15, they do another blank test to make sure there's no lingering contamination of alcohol in the breathalyzer, and then they do another sample test, and then they do a final blank test to make sure there was nothing wrong with it. So there we go. Kevin Flesher says, I'm 6 doses of NyQuil into the stream. Not going to be able to watch the whole thing. Here's my donation for the night. Thank you, Nick. Thanks, Kevin. Hopefully you can enjoy this tomorrow after a nice, peaceful NyQuil-induced sleep. Have a good night, buddy. Some Kind of Taco, Maddox's next book. I'm not as good as your kids. That would be the probably most appropriate title. So this is the procedure that happens when we have a stop, right? So this is the incident report. These are what these incident reports look like. They're very abbreviated. They're officer's notes. They are admissible in court at testimony, but usually the officer is there to clarify them and validate them or answer any questions that need to be asked about them or about any breaches of procedure that someone might identify. These are great tools for lawyers to go through and make sure things were followed. In this case, you know, I'm not familiar 100% with Michigan's process, but I will say that based on the outcome of this case, that this looks like it was followed sufficiently. And, you know, we go through some of this stuff. He fails a couple of the tests. Any one of these tests, failing them is grounds to do the portable breathalyzer test. And then failing the portable breathalyzer test is automatically probable cause to go in for an actual arrest. And then the compulsory test. Let me take a brief moment and talk about something I really dislike in regards to DUI process. And this is a personal pet peeve of mine, is that when someone is arrested for DUI and taken to the station for their test, they do have a right to refuse the test, but this is implied consent. So by driving, you impliedly consent to taking any sort of blood alcohol test if probable cause arises to administer the test. If you refuse that test, if you actively refuse that test, you can be charged with a crime. One, I think that's a problem because I think we can get warrants within a matter of moments at any time of day these days. So I don't think that this is a necessary thing. Paper warrants are no longer necessary in most courts. We can use phones, we can use text message, we can use email. A warrant application with the results of a field breath test should be easy to obtain within a matter of minutes from a magistrate judge, and I think we need to move towards a change to that. So I don't like the fact that you can be charged with a crime for refusing to consent to a test that basically amounts to something that is self-incrimination. To me, that's a violation of the Fifth Amendment. Supreme Court disagrees, but I think the Supreme Court's wrong all the time. Hatbuckles asks, can you not refuse all field sobriety tests and breath tests where he was? In Texas, you just ask for a lawyer. I don't know in Michigan if you can refuse. I know that in Minnesota, if you refuse a blood alcohol test, you are automatically at that point guilty of a crime. The state simply has to prove that you did refuse the test. If they prove beyond a reasonable doubt that you refused the test or you unreasonably delayed the test without any sort of justification, then you are guilty and they can charge and convict you, and they will. They will. Does kicking out a patrol car's window imply a refusal of consent? Not necessarily, actually. And you cannot impliedly refuse consent. You do have to expressly refuse consent, Or again, take actions that unreasonably delay the ability to administer the test. Typically, tests have to be administered within 2 hours of the arrest. So, kicking out a patrol car's window would not imply a refusal of consent to my knowledge unless it unreasonably delayed the administration of the test, like if you were getting pummeled by the police for breaking their car. What constitutes the implied consent? The implied consent that you give is that you have a driver's license and you drive on state-operated roads. That's how implied consent works. Hatbuckle says, if you refuse fully in Texas, you'll still get charged. There just isn't any official evidence. No refuse weekends will get warrants and draw blood. It's scary. Yeah, I mean, that type of stuff is really weird. Texas, I love Texas to death, but some of the stuff that they do in their criminal procedure, I would disagree with as a defense attorney. Mr. Kill Everything, what I learned when I was arrested, never say anything, talk to a lawyer. You do not know your rights. That is absolutely true. In the criminal cases I deal with, basically every one of them, the evidence comes from, not from the actual witnessing of the crime by the police officer or by a witness, but it comes from a statement that is made to the police officer during interrogation. And you should not, this is general advice, not legal advice, but really talk to a lawyer right now about this if you want. They'll tell you the same thing. Do not talk to the police without a lawyer present. Assert your right to an attorney. Call an attorney. Even if you don't have one, police officer are required to provide you a phone book to get an attorney on the phone. Get an attorney on the phone. Don't talk to police. You don't have to answer their questions many times beyond your identification. Have a lawyer in the room to answer those questions or to help you answer the questions or to tell you what you can ignore. You don't want to incriminate yourself, especially if you're innocent. If you're innocent, do not talk to the police ever. Pony Cordero. So the DMV invented adhesion contracts long before the internet. Possibly. I don't think implied consent is, it might be older than the internet, but it's actually not that old. So what constitutes failing the test? Could you fail the field test just not being particularly coordinated? Yes, Corey Jamnick. You could fail field tests by not being particularly coordinated, or, you know, perhaps you have some sort of dyslexia or disability that would prevent you from talking, going through ABCs forward or backwards properly, or counting improperly. This is a common problem with people with learning disabilities. But the idea is that, okay, they take you to the station, then you consent to the test, you blow into the breathalyzer at the station and you're not drunk, then you go home and everything's fine. Dax Desi asks, I'm an Article 4 free inhabitant, so I don't create joinder with the state by contracting for a driver's license or registering my vehicle. Drive at your own risk, buddy. All right. And Unicorn Shaped Building says, yes, if you're guilty, also do not talk to the police. But the reason I hammer on people who are innocent not talking to the police is because if you're innocent and talk to the police and they find a statement where they decide you're guilty of something, you will be charged with, or you could be charged with a crime that you are innocent of, and you really don't want to pay someone like me to defend it. Can I say the alphabet backwards right now? I can. I don't want to. Clay Early is in the chat. I have alcoholism. Does that mean they can't charge me because it's my disease? No. Hat Buckles, I've seen a case where the officer's witness account was thrown out because he was asked to perform the 1 foot FST field sobriety test in court during the trial and couldn't do it. Yeah, but I would say that those cases, while they do happen, are probably few and far between, because now, and what Michigan has done is they have basically, they have tested all of these field sobriety tests. They have done so in a pretty extensive and clinical manner, and they have actually come up with the probability that someone who fails the test is intoxicated based on getting people, you know, in double-blind control groups, intoxicated or not intoxicated, and having them perform the tests and then coming up with results. So, most of the states have sufficiently established that these tests are presumptively valid. Even if a police officer administering the test could not do it, the test will likely be valid so long as they follow the procedure appropriately. Corey Jamnick, wait, so I stumble trying to stand on one leg and then I blow a .00 and I get my CST impounded. It's possible. It's possible, but it's unlikely. Usually the field sobriety tests go to they go to raising enough cause to do the portable breath test. If you end up passing the test, usually your property is released to you without incident. You're not going to have probably not going to have an impounded vehicle when you pass all of the tests. Immortal Thor says the Miranda rights state anything you say can and will be used against you. They don't mention for you, and they don't mention for you because they will not be used for you. The things you say that are for your benefit to a police officer are often ignored or omitted from reports. They're not required to provide exculpatory statements said by you at trial. That is something your lawyer has to establish. The police are not required to corroborate that. Although, if they record it, oftentimes you can get the recording. Horizontal gaze nystagmus test is pretty crazy hard to beat or fool. I would think so. All right. So this is the incident report. This is what happens upon swerving and almost hitting a police officer. They will pull you over, and when you open your window and they smell a bunch of liquor coming out, and you look glassy-eyed, and you're slurring your speech like I will be at the end of this stream, that's when they move on. And it's important to note that this isn't the way that these sort of things play out. It's an escalating stage. Think of it like a video game, right? You pass level 1, that's swerving in front of an officer and almost running into them. Level 2 is they start smelling liquor and noticing signs in your communication that you might be intoxicated. Level 3 is they start doing the field test. Level 4, breath test, and so on and so on and so on. So this brings me to another point. When you are pulled over, it is to your benefit to say as little as required to a police officer. Generally, you have to play all of these things. You have to play all of these things in a way that feels right at the time. But it is because, sometimes it is beneficial to just say what happened based on the officer's attitude. Not every officer is out there to ruin your day, but you should initially approach the situation as if they are. Because that's kind of their job. It's not their fault. That's just what they do. So when they come to the window, what you're required to do is to provide the information requested, which would be a driver's license and either an insurance or registration card, depending on the state. In Minnesota, we don't really have registration cards. We have license and insurance requests. In Michigan, they clearly have license and registration requests. So you provide that information. If you're a concealed carry holder and you are carrying, you're typically required to provide that concealed carry license as well and inform the officer that you are carrying. I would avoid using the word gun, but providing that license kind of gives them a tip off, and then they may ask you about your weapon and where it's located, and you can give that information to them. Gatscat says, wait, so you are telling me that it's not smart to drink and drive, then swing at a cop? Been doing it all wrong. Yes, it's a very poor choice of sequence of events, and I would not recommend that. Chris McLean, why can you compel someone to provide their body fluids, but you can't be compelled to testify against yourself? The court has created this idea that testifying yourself is compelled speech. Testifying against yourself it's a violation of the Fifth Amendment. You don't have to provide an incriminating statement, but it's also a violation of the First Amendment, as it is compelling you to give out speech that you wouldn't otherwise do. Whereas bodily fluids and various biometric data is not speech because it is a part of you. It is not some sort of expression that you are doing. You're not expressing your fingerprints. You're not expressing your breath or blood or urine. You might be expressing urine, but by a literal sense, but it's not an act of expression. It's not an act of speech. So that's how they draw the distinction. Again, I think that is a fiction. That is a problem in these things. I think they should have to get a warrant for it. For My Devil says, how much do we need to donate to show us your hog? I don't have a hog. I do not have a motorcycle. So there's that. All right. Kind of got derailed. Where was I going with this? Who cares? Let's move on. So the next step, where are we? So these are the Michigan laws. So this is an interesting piece, and it's, did we? Okay. I got these out of order here. Let me swap those around. Sorry, man. This is YouTube. Family friendly. We will have no nudity on stream. I apologize. So this is, maybe I just breezed past this intro here. So this is Kevin Landau, and as defendant, people of the township of West Bloomfield. So this is the 48th District Court. And I'm going to bring this up because what I have been told by a couple people in Michigan who are either attorneys or involved with the law somehow, that the 48th District Court is the last place possible that you want to be charged with a sort of operating while intoxicated charge. Apparently, the court is very strict on these. You do not get the best shake from the court, and that any lawyer in the area would know about this, and so that makes this a little bit more embarrassing. If it can get more embarrassing, I'm not sure. So this is a brief of Kevin Landau, and is written by Arthur H. Landau, who I believe, on information and belief, is Kevin Landau's father, a practicing attorney in Michigan. I don't know if he's still practicing or if he has since passed the practice down to his sons, Kevin and Zachary. But he was at one point a practicing attorney, if he is not still a practicing attorney. So this is a brief requesting oral argument, and the brief is, here's what happens. Okay, so we saw the incident report, and we saw what happened at the station. He went to the station, he consented to the test, he blew a .15. Here's the reality of DUI. You are guilty. You are guilty of... like you blow a .15 into the intoxilizer at the station after consenting to the test. You're guilty, and now you have a really tough job of providing some sort of defense to that guilt, finding some sort of problem with the process, failure to establish probable cause, problem with the testing equipment, something like that. But it's a really hard battle. I barely touched my wood alcohol. This is wood-free alcohol. This is rye, unaged, so there's little wood in it. And yes, I have barely touched it. It is really, really, it's really strong, grainy. There we go. Yes, we should find out what Mr. Landau drinks and mix it all up and call it the Intoxilizer Hat Buckles. All right. So once you hit that .15 and you've blown in, you're presumptively guilty. You're likely going to be found guilty of a crime unless you can find some way out of it. So a typical, if I were looking at this case, I would look for a potential error in process, a potential error in the collection of the evidence, a failure to obtain consent, something like that. If I cannot find that, my advice to the client would probably be to plead guilty, and we would negotiate a plea deal. Sometimes it's not worth fighting when they have extremely compelling evidence. In this case, they believed they had violated some of the process. And we'll get into that real quick here. But this is their brief requesting oral argument before a judge to what they requested at trial was a pre-trial motion to determine that the evidence was valid or invalid. And the evidence that they're talking about is the administration of rights, and I think something about the sobriety tests, and it'll say it in just a minute. But so they requested a pretrial hearing on the evidence. That pretrial hearing was denied by the district court judge. For my devil, is it illegal to have a bunch of liquor delivered to Landau's office? I don't know that it's illegal, but I would advise against sending Landau anything. There's no reason to do that. And the stream is dropping, but it will come back. Just a moment. I would not advise sending anything to him. That is, polite education and mockery is one thing. Actually bothering a man where he works, I'm not a supporter of that. So I don't know if it would actually be illegal, but it's just not something that we need to advocate doing. All right. So let's get into this brief. So statement of relief sought. Defendant appellant respectfully requests the order of the 48th District Court Judge Diane Dickow D'Agostini in this matter be reversed and an evidentiary hearing on the chemical test and advice of chemical test rights be scheduled at a date prior to any scheduled trial date. Now, I don't have the document for it, but the reason that the order denying the hearing was granted or was given is that the judge said you don't need an evidentiary hearing. The evidence will be decided at trial. You just go to trial. You don't have a pretrial motion to determine if something can be admitted at trial. That's, that's a tough ruling, but you kind of have to deal with that. If you're going to object to evidence at trial, you typically do have to object to it at trial. Now, there is a pretrial hearing that you can have to suppress evidence. You make a motion in limine to suppress that evidence, but you have to have a reason for the motion in limine. You don't usually get to ask for an evidentiary hearing. You make your motion, and the court will determine if there's an evidentiary hearing or not, based on the legal ramifications of your argument. If you show that there's some sort of thing that should have happened in regards to evidence and didn't, then the judge might have a hearing to request further information on it. But you don't just get to ask for an evidentiary hearing to bring everybody into court, to start asking questions, to maybe come up with something. Hatbuckle says, Congress shall make no law abridging the freedom of shitposting nor the contents of mean tweets and accusations of cuckoldry when. That should be the newest amendment. We should put forth that. Thomas Romero, lots of names, says, is it illegal to send liquor to your office? No, it is not illegal to send liquor to my office. That is how this bottle of jewelry came to my office. It was sent by Keck7Go, which I really appreciate. No map hearing. Are you talking about map versus Ohio, Kenster? Ashley Princess says, I object to all evidence against my client, sir, because we might lose then. Yeah, and that's basically what happened here. And this is, to the credit of Arthur Landau. This is zealous advocacy for his client, who happens to be his son. Right, Arthur? Yeah, Arthur Landau. This is zealous advocacy, and he is trying for any angle here. But the fault that he comes into is asking for an evidentiary hearing instead of asserting by a motion in limine that the evidence needs to be suppressed, at least in my opinion. Is it legal to ship liquor across state lines? Yes, Elijah Watson, as far as I know, it is legal. Typically, the person receiving the liquor would have to be 21 years old. But yeah, and there may be some special procedures for shipping it that you'll have to check with the postal service that you're using. But yes, liquor has been shipped to my office. It can be delivered by various liquor stores as well. What's the worst whiskey you've ever imbibed? Let me think. Really, it's unfortunate. It was a Lagavulin 16, I will say, but it was not a good Lagavulin 16. It was a Lagavulin 16 that had been sitting out way too long, exposed to way too much air and way too much light, and had gone bad. It was not good, and it makes me want to cry. It was the saddest glass of liquor I've ever bought. Who's more competent, Landui or Papa Landau? I do not have enough information to make that assumption, but I will say that Papa Landau, who drafted this, appears to be more correct on his apostrophes. Am I at least 21 years old? Yes, I am 36 years old. So USPS says it's illegal. FedEx is the only one that will do it without import-export licenses. Monster Slayer, what are your favorite non-whiskey drinks? Non-whiskey alcoholic drinks. Vodka cranberry juice is great. I know it's kind of a fruity drink, but I really enjoy it. And I love very sweet white wines, ice wines and Moscatos. Really great for relaxing for me. Clay Early says to focus, quoting Tess. All right. So, statement of facts. Yes, let's get onto this. I have a million documents. I don't think we're going to get through all of them. Some of them are for a separate case. Yeah, the Mapp versus Ohio, Mapp hearings, you know, Mapp versus Ohio is about, whatchamacallit? Oh my goodness. They're Fourth Amendment searches. And in this case, you know, you're not going to ask for a Mapp hearing on this stuff. Again, if there's a problem with the evidence, you'd make a motion in limine to suppress the evidence. My favorite non-alcoholic drinks, sweet tea from the South. That's where it is. No one considers you suspect with all the alcohol arriving at my office. Not yet. Not yet. Yeah, as for the Mapp hearing, again, if there's a problem with the evidence, you assert the factual problems with the evidence, and the court may determine that you need a hearing to have, or you need to have a hearing on it. But that, you know, like just asking for a hearing, because that's what they're doing here. Asking for a hearing looks like a fishing expedition. It looks like they're really trying to, sorry, I'm going to tip my camera down. It looks like they're really trying to just delay and stall things out. Okay, so statement of facts. In this matter, defendant was arrested in West Bloomfield Township on November 22nd, 2006 at approximately 12:22 a.m. for operating a vehicle under the influence of intoxicating liquor. Defendant was compliant with the officer's request at the scene, and when taken to the police station, he consented to taking an evidential breath alcohol test, the result of the chemical test being 0.15. Defendant asserts that he was not advised of his chemical test rights either prior to, at the time of, or immediately subsequent to the breathalyzer at the station, as required by MCLA 257.625A and B. Okay, so I have those right here. So it's 2.57625A, 6A is the actual citation he's looking for, and 6B. So the following provisions apply to chemical tests and analysis of a person's blood, urine, or breath, other than a preliminary chemical breath analysis. So this does not apply to your field breath test. Arbin Gordon says, the real sweet tea where you die from diabetes as the tea hits your tongue. Yes, that's the best. Brewed with the sugar in it, not sugared after it has been chilled. The sugar should be brewed into the tea while it is hot. If you don't do that, you're not making proper sweet tea. Okay, so here are the provisions. The amount of alcohol or presence of a controlled substance or other intoxicating substance in a driver's blood or urine, or the amount of alcohol in a person's breath at the time alleged as shown by chemical analysis of the person's blood, urine, or breath, is admissible into evidence in any civil or criminal proceeding and is presumed to be the same as at the time the person operated the vehicle. So there you go. So then B, a person arrested for a crime described in section 625C1 must be advised of all of the following. 1, if he or she takes a chemical test of his or her blood, urine, or breath administered at the request of a peace officer, he or she has the right to demand that a person of his or her own choosing administer one of the chemical tests. So that's interesting. 2, the results of the test are admissible in a judicial proceeding as provided under this act and will be considered with other admissible evidence in determining the defendant's innocence or guilt. 3, he or she is responsible for obtaining a chemical analysis of a test sample obtained at his or her own request. 4, if he or she refuses the request of a peace officer to take the test described in subparagraph 1, or I, a test must not be given without a court order, but the peace officer may seek to obtain a court order. And 5, refusing a peace officer's request to take a test described in subparagraph 1 will result in the suspension of his or her operator's or chauffeur's license and vehicle group designation or operating privilege, and in the addition of 6 points to his or her driver record. So, here it clearly lays out these disclosures must be given to a person arrested for the crime. Now, what's interesting is that the argument of Arthur Landau is that these must occur before the test is given. But interestingly, that's not stated in the statute. It does not say that it must be done before, although presumably that's the only time it makes sense. Maddox Lost asks, is amber color whiskey indicative of quality, or is that inherently wrong? It is inherently wrong, mainly because whiskeys, one, they get the coloration partly from the wood of the barrel that they age in. So you have different types of wood, different darknesses of wood. That's going to confer a different color to the whiskey as it ages. Two, the other problem is that many whiskeys are colored with an artificial colorant. And so you can't really rely on the color unless you know that the whiskey does not have any sort of artificial color added. Then you can use the color as more of a tool to determine it. But you would want to make sure of that. All right. So he's stating that that he was not advised of his chemical test rights either prior to, at the time of, or immediately subsequent to the breathalyzer at the station as required. I would say that these three things are not actually required by the statute, but they may be required by case law. I'm not positive on that. I don't want to pretend to be an expert. Kev the lawyer says, I demand that my test be administered by Ally McBeagle. All right. So the case presently pending in 48th District Court before Judge Diane D'Agostini, being case number whatever. On January 12th, defendant filed a motion to challenge tests requesting an evidentiary hearing on the qualifications of the chemical test operator, the methods and procedure used in administering the evidential breath alcohol test, which is the data master, the time lapse and condition of defendant between his arrest and chemical test, the length of time the data master operator observed defendant prior to the test, whether the testing device was reliable, and whether defendant was advised of all of his chemical rights under MCLA 257.625. Judge D'Agostini denied defendant's motion for an evidentiary hearing to challenge chemical tests for a failure to advise defendant of his chemical test rights, the written order being entered by the court on March 22nd. So then they filed a claim of appeal, asked the court for leave to appeal, and on that order. So they're just appealing that order. They're not appealing the overall ruling, just the order denying the evidentiary hearing. So there's that. Good job, Arthur Landau, I guess. So then here's the response from the plaintiff. This is where here's a statement of facts. On or about January 12th, defendant appellant filed a motion to challenge the chemical tests and a memorandum of law with the district court. The plaintiff appellee filed its response to the motion attached as Exhibit 2. The district court judge denied the appellant's motion and set the matter for trial. The defendant appellant then filed this interlocutory appeal. So the standard of review is, so the appellee defendant accepts the statement of facts contained in appellee plaintiff's brief as complete and correct. I'm not sure what that has to do with the standard of review. The standard of review should be clear error, if I remember right. I think they say it here. Let's see. Standard of review is just not listed. Oh, there. Page 3. Oh, the applicable standard of review. My apologies. So the defendant appellant asserts his right to evidentiary hearing to determine whether the 4 foundational requirements have been met for admission into evidence. The standard of review is clear error in denying the evidentiary hearing. So clear error is a standard that you apply to the judge's decision. You determine if their ruling on the law was clearly erroneous. So are they wrong on common law or statutory interpretation? So the argument from the state is, of course, that the trial court did not commit reversible error. So review here is limited to the record developed by the trial court, MCR 7.210A. Therefore, the sole issue to be decided is whether or not the defendant appellant is entitled to an evidentiary hearing based only on his motion and the response and the brief record created at the district court. The defendant appellant's original motion attached as Exhibit 1, although entitled Motion to Challenge Chemical Tests, actually requests information the people pursuant to MCR 6.201. However, 6.201 is a discovery rule that the Michigan Supreme Court has clearly stated in Administrative Order 1999-3 that MCR 6.201 does not apply to misdemeanor cases and there is no mandatory disclosure required of the prosecution and is inapplicable to a motion to challenge chemical tests. So here we have the state asserting that Arthur Landau doesn't have the authority to actually request the discovery that he's requesting, or that he can request it, but the state is not obliged to provide it, and since this is a misdemeanor case. And you'll find this in several states, that misdemeanor procedure is different from felony procedure, and there are different requirements as the charges are not as serious as to what needs to be provided as a motion or on a motion for discovery or as required initial disclosures. So, nonetheless, the defendant appellant's motion then has some paragraphs citing the criteria for laying a foundation for the admission of an evidential breath test as set forth in the defendant appellant's memorandum of law citing People versus Krulikowski. The motion then requests from the court a hearing and determination of certain facts. On its face, this is going to be good. Defendant appellant's motion is nothing more than a demand for the people to lay a foundation for the admissibility of the evidential breath test prior to trial. The motion alleges no error of law, but rather demands finding of facts by the trial judge and not the jury. This is what I was saying earlier. If you have determined that something is incorrectly done as far as the law goes with regards to discovery or with regards to, a piece of evidence being provided to the court, then you have to assert that error of law and request that the evidence be suppressed. You don't just get to ask the court to determine if the evidence is good or not ahead of time, because the court will do this at trial. If laying foundation is part of introducing evidence at trial. So if you're not familiar with how courts work, when you have evidence and you want to introduce it to the court, you have to have a proper basis or foundation for it. You establish this foundation in any number of ways according to the rules of evidence. Lots of times that evidence is, the foundation is laid by testimony from someone with knowledge of the evidence. In this case, what you would do to implement this evidence is probably haul in the officer who administered the breath test, have them testify to the truthfulness of the test results, have them testify to knowledge of the actual documents with the breath test results on them, and state that, to their knowledge, they were accurate and correct, and they would testify to the procedure by which they, established or by which they administered the tests. And then when you then go to introduce the evidence as a prosecutor, you would attempt to introduce the blood alcohol test results, and the defense would have the opportunity at that point to object to those results. And you would object based on improper foundation if the foundation was improper. And that would be the time to do this. You do this at trial unless the judge gives you an evidentiary hearing for some sort of reason before trial. In Minnesota, sometimes there are pre-trial conferences in which any of these evidentiary issues are allowed to be brought by party on written notice to the judge. And then at that point, in Minnesota anyway, you can try and hammer out these things ahead of time, because evidentiary issues are not up to a jury. They're always up to a judge. They're a matter of law. So they are not left up to lay people. They are left up to an expert in the law, which presumably is a judge. So hopefully that helps you understand the boring aspects of laying foundation and introducing evidence at a hearing or at trial. Fishmonster123 asks, would you rather be forced to drink only PBR for the rest of your life or take a swift and savage kick to the balls? Second one. Unicorn-shaped building says, do you think it would be a good strategy for Landau to file a restraining order against the arresting officer? Yeah, I think what he should have done was filed a restraining order to prevent him from speaking in court. That would probably have helped. And that's probably not a violation of First Amendment anyway. So moving on, the motion alleges no error of law, but rather demands findings of fact by the trial judge, not the jury. The proper time and place to argue whether or not a proper foundation is made for the admission of evidence is at the time of trial. Plaintiff appellee can find no authority whatsoever that establishes a requirement to lay proper foundation for the admission of evidence prior to a trial. Moreover, all the Michigan authority discussing admission of evidence are reviewing the case on appeal after the trial, not before, and reviewing whether or not the trial court correctly decided to admit evidence or not. So what they're saying here is that the proper place to do this, the proper avenue is to for them to try and introduce it at trial, for the defense to object, and for them to have the legal argument there at trial. And then if they still disagree with the judge's ruling or the judge's discretion in admitting evidence, which is broad, judge's discretion in admitting evidence at trial level is very broad. But if they disagree with that at that point, they can then appeal it, and they can appeal it for clear error at that, after the fact. The problem with this, and they note this somewhere, but I'm not going to read through all of this document, because if I read through all of the documents, this will take decades. But the problem with this is ultimately, if Landau is acquitted of the DUI, then none of these evidentiary motions matter at all. That's what makes it improper. If he wins, then nothing, it doesn't matter if it was wrong or not if he wins. Now, that is a slightly disingenuous approach by the prosecutor, I will say, and prosecutors sometimes are disingenuous in their approach to these things, because yeah, sure, if he wins, it's moot, but if he loses, and if he loses due to an error of law, then that's unfortunate, and he shouldn't bear the burden of that. Sorry, Lady Rackets told me to be very careful with my male parts, because we may not be done having children yet, and we wouldn't want to damage anything like that. So that's where we stand on this motion. This is about done. The defendant appellant has included additional claims and arguments in this appeal that were not presented or argued at the lower court, and he seems to have passed that down to his son. If you've been following the lawsuit cases, you'll notice that in Kevin Landau's motions, he tends to try and bring new arguments or bring new evidence to his motions that should not be permissible, because you need to bring them in the initial complaint or the initial filings. Do you have one of those 10-seater transport vehicles? I have a 12-seater transport vehicle, actually. It's very fun. We just got it this past summer, and it's been wonderful traveling in a 12-passenger van as opposed to in a minivan, which runs out of space very quickly. Pony Cordero says, going on a cruise next month, should I smuggle liquor onto the boat or pay $364 for the liquor package, which gets me 15 drinks a day? I consider your answer almost legal advice. Man, I don't know if you... What cruise are you going on that doesn't have the full open bar? 15 drinks a day? I mean, I guess I don't take cruises, so I don't really know. I don't know. It depends on what the punishment for smuggling liquor onto the boat would be. And how much liquor you can smuggle. Because can you smuggle more than 15 drinks a day worth of liquor onto the boat? Or do you need that much? I mean, maybe you only need 6 or 7 drinks a day. And if you could get that in, that'd be the real question. Carnival Cruise. I don't know, man. That's a tough call. You want to make sure you are sufficiently liquored for whatever duration that you have. And if you can smuggle that in, what are they going to throw you out on the ocean if they find out? I don't know. No, they're that way on Carnival. They call it their unlimited package too. Sue them. Ooh, that's brutal. That's brutal. I took a laxative. Any advice? Bring the stream via phone to the toilet with you. All right. So moving on, moving past this document, we now have a transcript, and I'm going to put it to a quick, very informal poll. Do you guys want me to read the entire transcript, or do you just want me to read the judge's ruling on the transcript? It's about 12 pages. So very informal poll. Go while I drink. I just leaked what client's name? The entire transcript. The funny parts. The answer is yes. Read it if it's funny. You know what, guys? Give me one moment. Very unprofessional. I have to step away from the computer because I am omitting something very important that I need to do. I'll be right back. Right back. All right. Sorry about that. But this is very important. Mad Cucks, I will not clean this room. I can't. This room is the storage. This is the storage room. Actually, I am working on getting something done about it, but it just takes a lot of time because, like I said, this is where stuff goes to die. And if you have listened to Dick's show number 91, Dick on Portland Road Rage, his rage was involving the fact that men create giant piles of stuff, and those piles of things, we know where everything in them are. And that is never more apparent than in my particular offices. I have piles of junk everywhere, and I know that's how I've organized things. Skip to where the judge stops him. Just a second. Okay, so I wanted to bring out that a dickhead has sent me, which I just got today, this wonderful item. Very important to have. This is a roll of toilet paper. And let's see. If you can see here, this is very blurry, but it is George versus Dick Masterson. And this is the lawsuit on a roll of toilet paper. And I'm very appreciative of that. That was sent to me by Peter Pajitnov. And that is awesome. Thank you so much. I was not able to get to Portland Road Rage. So I was really glad to get one. So that is really thank you so much, Peter, for sending me that. And that is awesome. Where'd your goofy hats go? Clay, they're right here. I just decreased the frame. Here are the two goofy hats that I have in the room. You know, they're next to a bunch of empty liquor bottles. 12-seater means you're planning to have a full Rekieta jury. Yes. Now Landry can sue you for defecation. Oh, goodness. All right. Let's hold on just a second. All right, let's go through this. So, skip to where the court stops him. Yeah, because Landau's argument here isn't great. Well, I don't know. We'll read through it. This will be fun. So this is Landau's argument. These are how these oral arguments go. You have to do it in character voices. Oh man. All right. How should I do Mr. Landau? Is like an old coot, like, if the court has any questions, I'd be most happy to go ahead and answer them, but I would like to reiterate the fact that a motion for chemical tests and to challenge the chemical tests and the advice of chemical tests rights was filed in 48th District Court. As your honor is aware, this is an OUIL case, and we are contesting, number one, the fact that the arresting officer did not advise the defendant of his chemical test rights as mandated by MCL 257.625A and B. The defendant contested he was never advised of his chemical rights and therefore was not at liberty to go ahead and exercise any of those rights. People v. Castle indicates that if those chemical test rights were not advised of, then the case must be dismissed. And that's 108 Michigan Appellate Court 353, 1981. Matt Tobin, weekly Scotch/Bourbon contribution, looking for recos, my dude. Let's see. The Scotch recommendation that I cannot give enough right now is the Balmore 15 single malt darkest Scotch. It's right here. This one, you know, some random whiskey of the year award. And I mean, this is phenomenal. Have it now. I can't recommend it enough. I mean, I love Lagavulin and smokier scotches, and Balmore is a low smoke Islay Scotch, low peat Islay Scotch. But it is phenomenal. That is a phenomenal taste. So I hope that is sufficient for you. Thanks a bunch, Matt Tobin, and thanks a bunch, Guns Beer Freedom, for the donation. Big Seti says use Scooby-Doo voice for Landau. I do not do a good Scooby-Doo voice. But I'm gonna go on with this like weird sort of Grady, almost Alex Jonesy voice that I've got right now, and I'll figure out what to do. If you have any celebrities, throw them up in the chat, and maybe I can. If it's one I can do, I'll do it. Let's see. The defendant contested he was never advised of his chemical test rights and therefore was not at liberty to go ahead and exercise any of those rights. People versus Castle indicates that if one of the chemical test rights was not advised, or if those chemical test rights were not advised of, then the case must be dismissed. I already read this. In addition, Your Honor, we are contesting the authenticity of the data master results. I believe that we have to have an evidentiary hearing prior to trial to determine whether or not the data master was properly administered, namely that the operator was properly qualified, and the methods and procedures used in administering the test were in accordance with the Michigan State Police Manual for doing that, that a reasonable time elapsed between the time of arrest and the time of giving the chemical test, and the reliability of the data master itself. Someone dropped a Christopher Walken. I'll try that for the prosecutor. How's that? Gats, how many chugs could Landwy chug if a Landwy could chug drinks? Landwy needs more slurry speech. This is Landau's dad. We have no evidence that Landau's dad is a hopeless alcoholic. You do not besmirch the good name of my fellow Austinite Alex Gay Frogs Jones. I would never besmirch Alex Jones's name. Say they're putting chemicals in the water that's in the Alex Jones voice. They're putting chemicals in the water that's turning the frogs gay. I don't know if that was any good, but all right. We don't know whether or not, in fact, it was properly administered and whether or not the test was, in fact, a reliable data master result. And in order for those chemical test results to be admissible in evidence, those 4 foundational requirements under People v. Krulikowski, that's 60 Michigan Appellate 28, 1975, must be determined. And under MCLA 257.625A and B, it mandates that a defendant be given his chemical test rights at the time the test is being given to him. Matt Tobin says, obligatory Lady Rackets donation. Yeah, what we need to do is get her to do some impressions. And MCLA 257.62, and MCLA 257.625A and B says, and I'm quoting to begin with that, the arresting officer must advise a person being arrested for OUIL of the following test rights. And it says, shall be advised, which is reiterated by the case law in People versus Castle and so on. That number 1, and I'm quoting, that if he or she takes a chemical test of his or her blood, urine, or breath administered at the request of a peace officer, he or she has a right to demand that the person of his or her own choosing administer one of the chemical tests. And 2, he has to be advised that the results of the tests are admissible in the judicial proceeding as provided under the Act, obviously together with other admissible evidence. These rights were not given to the defendant. He asserts they were not given. An informal discussion with the arresting officer that I had, he didn't know whether he gave them to him or not, and that's what he said to me. Guys, like an informal discussion is not proper to raise in a in an appeal of a denial of an evidentiary hearing, but that's okay. He said, I don't know if I gave them to him or not, and I think we have to have an evidentiary hearing because an evidentiary hearing on both of these issues could very well be dispositive of the case, and this case may never go to trial. And what I'm asking for, Your Honor, is that if we're not allowed to have an evidentiary hearing of this kind to determine these things, then if we go to trial, it's too late. It's simply too late. These are critical items in the defense's defense in order to either dispose of the case or properly prepare for trial, and a trial is just simply too late. And very frankly, Your Honor, because it was frankly before, but it's very frankly now. Very frankly, Your Honor, in 48th District Court, before this judge, I don't think I'm going to get a fair trial, and I've never said that before in my entire legal career. Citation needed. I'm never saying that before. I would bet that that is not true. But I don't think that I can get a fair trial before this judge, and I would ask the court to allow the evidentiary hearing because it could very well be dispositive of the case. It's something comparable to like in a felony case where you're contesting the legality of the search and seizure, and you have to have an evidentiary hearing to determine whether or not, in fact, it was legal, whether or not all proper procedures were followed in the arrest and in the seizure, because that could very well be dispositive of the case. or in a Walker hearing where somebody is contesting the voluntariness of his confession, the same thing. If the confession wasn't voluntary, then obviously the confession is going to be suppressed. That even could be dispositive of the case, or at least will not allow the admission of evidence that is otherwise inadmissible. And there's not much of a difference in a case like this. This could be dispositive of the case, and what we're asking for, Your Honor, is a hearing prior to the trial because we were contesting the defendant was not advised of his chemical test rights. In an informal conference with the officer, he indicated he doesn't know if he advised him of his chemical test rights at the time. Tim says, did Arthur Landau just assume Kevin Landau's gender? Triggered. Big foul. Big foul, Arthur. You can't I think worse, Tim. I think maybe as his father, he's imposing a gender on him. And that is about as hateful as it can possibly get. That is very ungoogly. Fishmonster123 asks, is Papa Landau throwing up a Hail Mary with this move? Absolutely. Absolutely. Also, there was a tape that was taken, and for some mysterious reason, I believe a tape was made of the arrest itself, which really doesn't show much. And they go into the station, then when he administers the test and is talking to the defendant, that tape is mysteriously gone. Let me take a pause here. This is a huge problem. This is a huge problem in chemical defense, in that booking rooms and actually pretty much anywhere in a jail is recorded, and these recordings happen to disappear with ridiculous frequency. In my personal and professional opinion. Any video of a person at a jail that will then that is then charged with something should be preserved and available to the defendant on discovery. The fact that it's not is actually offensive to me. Pro, I don't know if when you're saying stop talking weird, if you mean that I'm talking weird when I'm talking normal or if I'm talking weird during Landau's voice. Your Landau voice sounds like 3 kids in a trench coat trying to buy an R-rated movie ticket. Yeah. Okay, so let's go back to this. It's blank, and all we see is a wall. And Your Honor, why that is, I can't answer it. I can conjecture, but I'd rather not conjecture. And what I'm saying, Your Honor, is this is a critical part of the defendant's case in this matter. I would ask that the 48th District Court be reversed and that there be an evidentiary hearing. Also, Your Honor, if the court does see fit to grant our motion, I would ask that the court retain jurisdiction of the case once the hearing's held, because, again, as of or remand it to a different district court for a hearing, because I don't think I can get a fair hearing before this judge. Thank you. Okay, thank you, says the court. So I'm going to attempt a Christopher Walken, but let me I mean, this is a big job. This is a big job. All I see is a wall, MAGA. I'm gonna lubricate the Christopher Walken voice just a little bit with some Balmore. Why are the indentations so weird? That's just how they do transcripts. They number, so they've got the numbering on the left side, which takes a huge. Carl Cuckington asks, is there any case in court that Landau won? I can't find one in New York. Now, he has several pending cases, and that does not mean he hasn't won them. Not all of his cases are available to be viewed through their e-filing system. So I don't want to misrepresent that he has never won a case. I have not found one that he has won yet. I just puked for the first time on your stream from drinking too much too fast. Drink? Yeah, Clay, that's another drink. Goss Demon, I love how he gives no reason for why he can't get a fair hearing from the district court judge. I know there's tons of case law on that. Yeah, the courts are presumptively impartial. You have a huge burden in showing that your court is impartial. Jason Benaham says your mic is muted. That gets me every single time. I just look down at the mute button because I sometimes move the mic about, and I have touched the mute button in the past. So, all right. Clay, don't die though. Like if you're puking, that's fine, but don't die. Okay. So, thank you, Your Honor. Your Honor, as you know, on an appeal, we're limited to the review of the brief, limited record that was created in this case and the motion that was filed by defense counsel in this case. And I feel like my walking is really weak tonight. If we review the motion, yeah, this is terrible. I'm going to have to stop. I think I'll get sued by walking if I keep that up. And with all due respect to defense counsel, his brief goes way beyond the scope of his original motion and the scope of the brief record created at the district court, Your Honor. No, I cannot do a Matlock voice. Sounds like a drunk Shatner. Probably not far from it. If we take a look at his brief motion, he basically in his first paragraph, well, guys, like when I'm just say it like Bill Clinton. Okay. If we take a look at his brief motion, taking a look at his briefs, you know, in his first paragraph, well, even before that, cites a discovery rule 6.201 that really doesn't have anything to do with the motion. It's a discovery rule applicable to felonies only and specifically not applicable to misdemeanor cases as pursuant to Michigan Supreme Court. Administrative Order 1993.03. 1993, that was a good year, boys. So I found that kind of peculiar with regard to the beginning of that motion. Arnie Wilberg versus YouTube thoughts / future shows. Matt, forgive me. Is Arnie Wilberg versus YouTube is Arnie Wilberg the YouTube recruiter who has sued YouTube and Google, or are we talking about something else? I'm not familiar with the name. Awesome, Bill Clinton. Thank you, Freddie Rush. I can deal with a Bill Clinton when intoxicated, probably because Bill Clinton usually sounds intoxicated. Tim says, next time Miss Rekieta appears, you must say, I did not have sexual relations with that woman in your Clinton voice. Hillary Clinton voice, not Bill. Okay, I can do more pointing. But if you notice, Bill Clinton does not ever look at the camera, and his pointing is not always on target. Because he has a problem when he lies, that he looks away from the camera. Herb Beta Patch says, I'm going to send you a bottle of Southern Comfort. Thank you. Do a Perro Mason voice. Perro Mason. Oh my goodness. All right. I'm going to continue reading in my regular voice, but if you got someone else, throw me out there. And, okay. So yeah, Matt Tobin says, yes. The Google affiliate being sued. Yes, I will be covering the, YouTube lawsuit, with the YouTube recruiter who is suing for discrimination based on being a white male. I will also be covering the lawsuit of the guy who threatened James Damore via internal messaging, who was also fired by Google, who says that he was discriminated for trying to uphold the discrimination, the discriminatory policies of Google. So that'll be interesting as well. That will all be covered as part of the ongoing Damore versus Google series. Those videos should be coming up soon. Bane. I don't have a crab to talk through. He indicates in his motion that the prosecution has a duty to establish a proper foundation for admission of the data master test results. I agree that we have a duty to lay a proper foundation at trial, but not beforehand, Your Honor. And that's the who's Rick Sanchez? That's the root of this, or the root of this motion is that again, this has to be brought at trial. This is not a pretrial issue. Seriously, this is not a pretrial issue, and them asking for a pretrial evidentiary hearing without asserting an error of law or an error of process at the beginning is really problematic. Those videos will not be coming up soon. Once they get transferred to YouTube Alphabet Team, I'll be shutting down your account for sexism, racism, and violence. Marty McFly. Oh. Oh, is Rich Sanchez, is that like Rick and Morty? I don't watch Rick and Morty, sorry. I don't really watch TV. What he's asking the court to order is that we basically have a preliminary exam to determine whether or not the people can lay foundation for admission of evidence, which we believe we'd be able to do, no problem, but that's by giving a blank statement that, hey, they have to prove it at trial, so I want them to prove it ahead of time, doesn't necessarily raise a question of law for a judge to determine in a case. Do it in my best Dick Masterson voice. I don't know if I can get the manly, shrill Dick Masterson voice nailed down. I'll work on that for a future stream. I'm not going to work on it on air. I don't want to kill you guys. I'm not here saying today or claiming that he's not entitled to an evidentiary hearing. I'm saying that in the form and fashion that he presented his arguments to the court in this case, he's not entitled to an evidentiary hearing. So basically, if he were entitled to an evidentiary hearing, he screwed it up. I've never heard of somebody saying, well, Your Honor, he has to admit that evidence into trial, so I want you to determine whether it's admissible or not. Do it as Mad Cucks. Welcome to the biggest problem in the universe. I'm your host, Mad Cucks. I can't do it as well as Mad Cucks, man. He's good. He's too good. He's not specifically challenged any particular rule violation. I'm not going to attempt to Peach Saliva voice. He has today, Your Honor. He claims that the officer never read him his chemical test rights. That was never brought up in the original motion, nor do I believe it was brought up on the record at the original court hearing where the judge denied his request for the evidentiary hearing. In number 2, he says the prosecution has a duty to provide defendant with exculpatory evidence. Your Honor, we happily provided the defense counsel every single thing we have in our possession with regard to this case, including going above and beyond the data master logs, the defendant's advice of rights, a copy of which was given to him at the time, and everything else which would normally come with that. Notice that. The defendant's advice of rights, a copy of which was given to him at that time. I don't know if that includes the chemical testing rights, but he was informed of rights at some point. I'm not short enough to do a Rucka Rucka Ali impression. Yeah, Peach, sorry. No, it's because female voices. I'm just not well versed. I could work on it. Do it in a Clay voice. Clay, I just said I can't do female voices very well. Do a Hitler voice. If I could speak German. In number 3, the arresting officer has a duty to provide the defendant with his chemical test rights. I'm not sure what he was claiming by that. Whether he's claiming as he is today that they were never read to him, I read that as saying we're obligated to provide him a copy of it, which we have done, Your Honor. So they have provided him a chemical testing. Right. Trevor Bird is a conspiracy. You're the real Mad Cucks. Sing a sexy song. I don't know. What's a sexy song? We might have to get Lady Rackets in here, although she's having some throat issues right now, so I don't know if she'd want to sing. And I'm guessing that's 9. I'm guessing that would prevent her from coming on stream, and she's probably going to open the door and yell at me in just a second. And then he goes into, again, the administrative rules for admission of the data master test. And quite frankly, he's not challenged anything in the lower court that would lead a judge to waste the time and have an evidentiary hearing. And some of these claims are no longer legitimate claims with regard to, let's say it was given within a reasonable time frame, as Your Honor probably well knows. There's recent court case law that basically says that that's no longer necessarily a requirement. It goes to weight, but it doesn't necessarily go to the admissibility of the data master results. Do Samuel L. Jackson. I try not to use the F word on my stream. Can you feel the lulls tonight? You got to give me a different song. Camptown Races is not a sexy song. Yes, I'm sure I'm not Bill Clinton. Lady Rackets has been ill the past couple days, so she has been mildly under the weather. Mildly, I say. To her credit, she has been great dealing with her illness. And more frankly, Kermit, okay, and more frankly, after post-wager cases, really the only requirement to satisfy is simple relevance for admission of the data master results under MRE 401 and 402. So I find it quite odd that we're here today to basically prove my case before the trial. The defendant has absolutely every right at trial to object to the admission of the data master results. I can't do Jordan Peterson because he's just too Canadian. Every case that talks about admitting data master results is a challenge after the trial. The attorney during the trial objects to the admission. Guys, I'm going to skip, basically he says that Landau is nuts. Swedish Chef. Have you considered being a voice actor? You are legit good. I have considered it. I just have no idea how you do it. And the less intoxicated I am, actually, I do some pretty mean voices when I'm practiced up. I am not practiced up right now, so I could do maybe an Alec Baldwin. But Bob IW 2038. I'm glad you're Canadian, but I cannot do the boots and the A's as well as necessary to do a consistent Canadian thing. Your Honor, I'm assuming that I forgot the Landau voice. Your Honor, I'm assuming that, well, strike that. If counsel would have read the motion hearing, every single item, the motion hearing on February 12th that we had on these issues, every single item that I brought up in my brief, I argued at that hearing. I have a copy of the motion here, and every single thing in my brief was argued at that hearing. He obviously has not read the transcript of this motion, because if he did, he would have seen all of the arguments contained in my brief or contained in this motion. I argued the data master and the lack of advice of chemical rights at length in this motion at February 12th. It wasn't that long of a motion. I don't know if you can... If you were on Fiverr, the Dick Show might hire you for Cool Sean. I don't think I could do Asterios. I don't know if I could do Asterios, man. Cool Sean. I could do a Cool Sean voice, I suppose. Everything in this transcript and in the brief is argued at that motion. So where he comes up with what he's saying, I don't know. But in addition, Your Honor, the arresting officer indicated to me the following morning after the arrest was at 12:22 a.m. Following morning after the arrest he recalls giving him his advice of chemical testing rights. The following morning, that's 8 hours later. Nope, wrong. So that was voice not deep enough, to be honest. I agree. I cannot do a full Cool Sean because I am just not manly enough for that. Yeah, Fishmunster 123, Landwy and Landad have a similar lawyering style. Can we get some Mickey Mouse? Yeah, just a second. I'll do I'll do a Mickey Mouse in a second. But let me cover this. Deny and repeat, repeat, repeat. So the repetition is actually, it's a rhetorical style. Let's talk about this because there is a ton of repetition in the lawsuit. There's a ton of repetition here, but it's a rhetorical style to just yell everything that Peach Saliva writes. It's a rhetorical style to reinforce subconsciously that a certain thing is true or correct. If you say it over and over again, people tend to start accepting it as fact. And it's a weird product, but you find it a lot when you have motions that are where you're really reaching for the argument, when you don't necessarily have legal support for it. You will... So we need a Lawsplaining of Georgia v. Denver, Fenton, Allen. Google it. I will. But yeah, so it's kind of a cheap attempt to cement an idea in the court's head, inception-wise, in the judge's head. But that's why you see the repetition so much. And remember, these are transcripts, and transcripts are people talking. And if you ever transcribe something you're saying in the natural world, it's never going to look good when it comes out. Let's see. Why do I feel the need to spend money to hear you say my nonsense? I don't know, buddy. I don't know, but I'm okay with it. So the court says, okay, this is where I am going to read the court's thing here because this is where he addresses the arguments. The court. Okay. This is defendant's appeal on leave. Maybe I should do an... Let me see if I can get into Alec Baldwin. Okay. This is defendant's appeal on leave granted from the 48th District Court. I can't do Alec Baldwin tonight. Oh my goodness. Guys, I apologize. My voice game is off. I will work on it for the next stream. Defendant is charged with OUIL in the 48th District. Defendant filed a motion seeking an evidentiary hearing prior to the trial. In order to challenge the admissibility of the data master test results, the trial court denied the request for an evidentiary hearing and indicated a decision in the admission of the results would be made at the time of trial. Christian Bale's Dark Knight voice.
Defendant filed an application for leave to appeal to this court, which was granted. The prosecution has filed a response to the appeal note, indicating there is nothing to support defendant's condition that an evidentiary hearing is mandated prior to trial.
Defendants first alleges the prosecution must lay the proper foundation before the data master results can be introduced into evidence. This is a correct statement of the law and is set forth in People v. Krulikowski. However, there's nothing presented to indicate the prosecution must lay the proper foundation prior to trial. And I and my legal staff were unable to locate and support any support for that position in independent research, not just relying on the briefs. Thus, defendant's claim of error in the trial court's refusal to grant an evidentiary hearing is without merit. Is without merit. Is without merit. This is the mantra of the Landau career, as far as I can tell. Is without merit. Defendant also argues the trial court erred in not conducting an evidentiary hearing on second basis. This is of Gilbert Gottfried. Man, this is probably going to be bad, but
Defendant alleges the arresting officer failed to read his chemical test rights to him, thus depriving him of the right to seek an independent blood alcohol test after submitting to the data master.
that sounds more like a drunk Bette Midler. Defendant contends that if the testimony at hearing shows the officer failed to administer the chemical test rights, he's entitled to a dismissal of the charge. Christ is with merit. Get keto, son. I agree, thereafter. I agree. I can't do the rasp. Honestly, like, the liquor is interfering with the rasp. However, the Michigan Supreme Court held in People versus Anstey case that the appropriate remedy for failure to provide the chemical test rights is not dismissal of the charges, but rather a jury instruction that the defendant's right was violated, and the jury can determine how much significance to attach to that fact. And this is a frustrating Keanu Reeves and Devil's Advocate. Whoa, I can definitely do Keanu Reeves. I totally forgot that I can actually do a passable Keanu Reeves, but it's more like Keanu Reeves from Bill and Ted's. I'm not sure if I could do Devil's Advocate. Let me see if I can undrunk myself enough to get into Southern Keanu Reeves. I think I can. Thus, the denial of an evidentiary hearing prior to the trial to determine the admissibility of the data master results is not reversible error. This court is going to affirm the district court. Sounds crazy to me too, but that's the law. The liquor is not interfering with the raft. That's because the raft is the most pure and most Christ-like I know. Okay, so the judge is even a little surprised by the law here, and let me take a moment to explain what just happened, since I was in character, and this is a little weird, but this is a weird aspect of our criminal system. So if you're in a criminal trial and your rights are infringed, the infringing of your rights, and this bothers the heck out of me, by the way, the infringing of your rights does not necessarily throw out a case. It only throws out the case if the infringing of your rights is considered to be prejudicial. And prejudicial, whether it's too prejudicial is a question of either fact or law, and it really it's very case specific. So, I'll do the Mickey Mouse voice. I apologize. The Denzel Washington Fish Monster 123. Denzel Washington does it for Lady Rackets, I think. This is a big problem. So if your rights, your constitutionally guaranteed rights, are infringed in a criminal proceeding, that it is only grounds for acquittal if the court determines that the infringement upon those rights is prejudicial to your ability to defend yourself. And that is a very specific question, and I don't think that this is a correct standard for things. I think that if they infringe upon your rights in any way, that should be dismissible, but I might be in a minority on that. I'm not sure. Let me see if I can get to Mickey. Okay, good night. I love you. Which impression does it for you? That's not a good answer. Lady Rackets is going. Is it Denzel?
Yeah, Denzel.
That's what I said.
Oh, I don't know. It's been a while.
She agrees. She agrees that it's Denzel. Anyway, Lady Rackets is headed to bed. So, good night, sweetie. Come here.
My robe.
Anyway,
Better get some money for me and my robe.
the Rafter says you're a minority, lol. I think so. Peach, I love my wife too. She's wonderful. Matt Tobin, save the hundo for a stream when she'll be awake. I hate to say that, for my own, monetary interest, but definitely save it for a stream where she can participate. I don't want you to drop money when she's headed to bed. But okay. sorry to derail this whole thing. But yeah, the idea that if the court violates your rights or the police violate your rights, that it's not automatically dismissible bothers me, but that's the reality of it. It has to be too prejudicial for you to defend yourself. Nick demands a kiss for anyone to leave his presence. His clients have gotten used to this. And now you have a throat infection too. No, she is on antibiotics, so I'm safe. She's been on them for a sufficient amount of time. But let's real quick. Let me get to that Mickey voice. However, in the Michigan Supreme Court held in People versus Anstey case that the appropriate remedy for failure to provide the chemical test rights is not dismissal of the charges, but rather a jury instruction that the defendant's right was violated and the jury can determine how much significance to attach to that fact. I hope that was an okay Mickey. It's kind of tough with liquor in the throat. But basically, the court upholds the denial. That's the root of all this. What they do grant to Landau is a 90-day stay, and that is over the objection of Grachowski. Grachowski says that the 90-day stay would potentially impair their ability to properly prosecute the case, because this is getting a little ridiculous on time. And I haven't focused on the dates of all this stuff. Maddox Less, Maddox dumb fan voice, please. Good job submitting a dumb question. We wanted Mickey Rourke, not Mickey Mouse. Yeah, so he does get a 90-day stay, and I haven't focused on this, but look how long after this. So this is so the case is, this is a misdemeanor case. And he was arrested on what, November 22nd, 2006? No. What? Okay. He was arrested on November 22nd. Where was that? Like November 22nd, 2000. I can do a Hank Hill sometimes. What he was arrested for was oh, my Hank Hill is difficult when I'm speaking off the cuff. What he was arrested for, or he was arrested on what was it? November 2006, something like that. Where's his fact statement? Let's see. Gosh, I am sorry for not remembering this off the top of my head. It's the liquor. I blame the liquor. Yeah, November 22nd, 2006. And this is November 29th, 2007. This is a year. This case has been going for a flipping year at this point. Read the prosecutor as a horrible blackface stereotype. That will never go wrong for you. Oh, thank you, Justin Brodak. Rocky Balboa. I could do a Rocky Balboa. Let's see what the next document is. I have a whole bunch more documents. We're not going to go through all of them because it'd take, like I said, forever. So, the important takeaway from this transcript is that the judge denies Landau's motion, but it does give him 90 days to appeal it again. Why don't I do that dang old Boomhauer voice? You know, dang writing motion for stay of proceedings. Now come defendant Kevin Aaron Landau and buying through his attorney, dang old Arthur A. Landau, and in support of his motion for stay proceedings says as follows. What's the average turnaround for a case like this? I mean, so you have a right to a fair and prompt trial by a jury of your peers, which typically, like if you demand to exercise that right, the court has to go ahead and have your trial within something like 60 days of your first hearing. If you waive your right to a fair trial, they can take longer. But I mean, we're talking like 3, 4 to 6 months. This is a misdemeanor trial. So even going to trial, we're talking about a 1-day trial, maybe 4 or 5 hours tops, getting all of the witnesses in there, and having jury deliberations. This should be done in 1 day. It should be scheduled out probably 6 months from the arrest date or less. There's no reason to be having hearings a year out to determine the admissibility of evidence. Can you do the regular Maddox voice? It's pretty simple. Just pretend you have the biggest dick in your mouth. How long to arrange a trial by combat? That should be much faster. What is the legal definition of prompt? The legal definition of prompt trial is, I believe, within, I think the way they look at it is like 60 days. I think that's the case. I don't know the actual official standard. Scott Severin, these Rekieta Law live streams are starting to become part of my Friday night routine. Me too, buddy. They're becoming part of my routine too. ERB beta patched. Will we see transcripts for the lawsuit? When you get to this, you're like a ways behind. So I apologize that this answer is going to come really late. If the transcripts are available for the lawsuit for any hearings, yeah, I'll happily cover them. But yeah, this is a year away. It becomes very difficult to start prosecuting these things a year out because witnesses do start to forget. You know, these cops pull over people every day, several of them, much to my chagrin, they do. And the fact that they're pulling over people every day means they're going to start to forget this individual thing. And that's probably part of Landau's strategy because he does not have a good case here. But if he can get them to forget various aspects of it or contradict their own testimony from before, you know, he can maybe impeach them on the stand and then possibly find an avenue to get it thrown out. Do you make your wife call you your honor or counsel in private? No, I married a strong woman and I don't make her do anything. Everything she does, including calling me your honor or counsel in private, is done of her own volition. You know, we have a partnership very much. So let's see. So this is a motion for the stay of proceedings. So this is where they request a stay for the purpose of we'll say delaying. The purpose is delaying trial. That's the whole point of this. But the purpose of asking for reconsideration, which they ask for here. So they're asking, or this is let's see. This is the objection to the motion for a reconsideration. So if you're not following the procedure because it gets very much lost in how ridiculously overcomplicated it is. But so they are going to trial. They asked for an evidentiary hearing. The evidentiary hearing was denied. They appealed the denial of the evidentiary hearing. They lost the appeal of the denial for the evidentiary hearing. So then they asked for a 90-day leave to request reconsideration of the denial of the appeal. And they were granted the 90-day leave to file for reconsideration over the objection of Grachowski, and they then made a motion to ask the court to reconsider its denial again. So that's where we are. Here's the motion opposing the raising objection to the appeal or to the reconsideration motion. Sorry, I'm losing track of how stupid these are, but this is really important. because this is something that Landau has a problem with as Kevin as well. Megadarsh says, can you do a Mark Humes impression? Also yams. Isn't a Mark Humes impression just like a silent Jason Voorhees mask? I don't have a Jason Voorhees mask with me. And I don't have any almonds to murder with a machete. But that'd be ridiculous. So here is this. Like I said, this is something that Kevin has a problem with in some of his current cases, which I'll be covering in the future here. But so let's get to the factual basis. That on March 28th, 2007, appellate defendant filed an application for leave to appeal with this honorable court from the 48th District Court. On April 28th, 2007, this honorable court granted the appellate defendant's application for leave to appeal. That on November, so that was the initial leave. On November 29th, this honorable court entered an order denying the appeal, therefore affirming the district court decision. All right, I can do Morgan Freeman. That on November 29th, 2007, this honorable court also granted a stay in the matter for 90 days to allow the appellate defendant an opportunity to file an application for leave to appeal in the Court of Appeals. That on January 24th, 2008, the Court of Appeals denied the application for leave to appeal. I hope that was a good enough Morgan Freeman for you. Deeper. That the appellate defendant was now filed a motion for reconsideration with his honorable court and has filed a precipice on the motion for February 20th, 2008. It sounds like Ken Burns more than Morgan Freeman. Stone cold. That the precipice filed by the appellate defendant certifies that the attorney for appellate defendant made contact with the undersigned on February 13th, 2008 to request concurrence in the relief sought. However, no such contact was actually made. So he says he contacted the the prosecutor, but he didn't actually contact the prosecutor. So that's a problem. Don't lie. Don't lie. Stone Cold, man, I am not prepared for a Stone Cold. I haven't watched any Stone Cold lately. See, this is the thing, guys. I have to actually like see and hear some of these voices recently to pull them out, and I can do them. I can do them. So here's what I'm going to ask you to do. If you want a specific impression, drop it on, send it to me on Patreon. Post it on Patreon or something like that. Send it to me in a message on Patreon, and I can maybe work on it. But some of these I can't just pull out. Donald Trump. That the precipice seeks oral argument on the appellate defendant's motion for reconsideration. However, MCR 2.119 F2 unequivocally states that there is no oral argument in a motion for reconsideration. Wrong. That pursuant to MCR 2.119 F1, a motion for reconsideration must be served and filed no later than 14 days after entry of an order disposing of the motion, and more than 14 days has passed because the order in this case was entered on November 29th, 2007. So the argument against this is that it was untimely entered. And this is a failure of procedure, which we have seen in other Landau documents, or I have seen in other Landau documents. I don't know if I have completely disclosed all of that yet. That might be an upcoming stream. At this point, the liquor is really starting to take hold. Barack Obama. That the November 27, 2007 order of this honorable court and the order denying the application for leave to appeal in the Court of Appeals effectively closes the case with this honorable court. Gatscat says, so Landwee's dad lies in the case, apple and tree. Yeah, that's kind of a point I wanted to get to, is that I don't want to ever go and stretch and say that someone has lied to Al Pacino. I don't want to ever go and hold on. I'll get to Al Pacino in a second. It's hard to do some of these like talking in my brain because my brain is slow. No Muslims were terrible Obama. No Muslims were bombed. Marty McFly. I don't know if I can shake enough to do a Marty McFly, but that was rude. Sorry, Michael J. Fox. I love you. Dean Winchester. Okay. I'm hesitant to call out. I'm hesitant to call out another lawyer for lying. I think they may misrepresent things, but lying is a pretty grave charge, and it's a breach of ethics, and there can be mistakes made, and so I'm hesitant to do that. But that's what the prosecutor is basically saying here, that he lied about something. We've seen Landau actually under court order or under court ruling have determined that he has pushed falsehoods on the court, and maybe he learned that from Dad, maybe not. I don't know. Michael Jackson. Don't be such an ableist. Thanks again, Justin Brodak, for that donation. Guys, so this is the end of the 2008, or 2007, 2006, 2008. This case goes all the way into 2008. This is, let's see. On 3/11/2008, Kevin Landau pleaded guilty to driving or operating while intoxicated, a misdemeanor crime. He was sentenced to 12 months of probation and $1,160 in fines. So that is the result of this case. He ultimately loses the case. He wasted the court's time. He wasted the prosecutor's time. He wasted the state's money with all sorts of motions that are really, really frivolous. Yes. That's what I want to get out. It wasn't quite 3 years. It was 2.5 years for a misdemeanor DUI case. And this is what happens when you have a lawyer for free, is that you are able to fight these things basically for just mere filing fees, and your filing fees in criminal cases are largely gone. So when you have a lawyer for free, these things can get drug out and bogged down with motion after motion after motion. Yeah, it was anticlimactic. He pled guilty. I'm not going to do a Chris Tucker. Not right now. Sorry. Oh my goodness. So this is the result. Now I'm not going to go through all the documents because we're at 2 hours and 12 minutes, 2 hours and 13 minutes right now. And I think it's about time for me to start wrapping up this stream, which means it's only like an hour away from being done. But there is another case. There is another DUI case, and this is 2012. He was actually pulled over in 2011. So he was pulled over 3/25/2011. So we're talking almost 5 years and 14 days. 5 years and 14 days after his first DUI conviction. But how long did he lose his allowance? I don't know. Do Jackie Chan. Since you are homeschooling your kids, are you giving them an authentic childhood experience by bullying them and calling them nerds? Absolutely. He drank 6 too many intoxilizers. So the next case was 5 years and 14 days from the date of conviction. And the problem, thanks Clay for reminding me to focus. The problem he runs into is that this is a second charge, which aggravates the charge and causes him to lose his license. So I'm not going to go through these documents because I don't want to keep you guys on the stream for like the next 4 hours. But you can't see this unless I move the Patreon thing. So I'm going to briefly move this, and I want you to notice something. So I've got a bunch of documents on my Adobe here that is showing you guys what's up. A bunch of documents on the Adobe. And if you look at the first 4 numbers on each tab, that's the date of all of these things. Mind you, this guy was pulled over in March of 2011. Now, if you notice, this first one here is from March 2012, March 2012, March 2012, June 2012, June 2014, December of 2016. This is how long they are dragging out these cases. So remember that you guys in Michigan are paying for people like Landau to drag out these criminal cases, and they're really have no foundation or basis. 2 more hours, the mob has spoken. I don't know. Do you guys want me to talk? Like, do you want me to go through his next charge? I can start it. It gets really long, and I don't know. If you guys want to keep watching, I will keep going for a while, but it's 2 more hours is a long time. Oh no. Oh no. I should never leave my life to your whimsy, should I? If you're going to do more voices, yes. All right, give me some voices. I'm going to lubricate with a little bit of hibiki. I do not have the police incident report from the 2011 DUI. I am sorry, I don't have it. It was not given to me. I have a separate incident report that is unrelated to DUIs that involves Mr. Landau, but I do not, I really don't want to bring that one out because, one, no charges were filed. Let me be very clear on that. In the second incident report, no charges were filed. It was just a concerned citizen call. And I don't want to imply that he was doing something illegal in that second, oh, Joe Pesci. Forrest Gump as Landau. Okay. I can maybe do a Forrest Gump. But I don't want to imply that he was doing something illegal in that second incident report, so I'm not going to release it. Let me tell you that incident report amounted to no charges, no trial, no convictions, nothing like that. I do not have the incident report for his 2011 DUI. Bill Murray and Caddyshack as land dogs. No, it was not domestic violence related. Fishmonster 123. It was literally like he was outside on a phone, and some people were curious as to why he was outside on a phone in like a driveway. And some people make weird calls to police, and giving Landau the total benefit of the doubt. Sometimes people call the police and there's no reason to do it. Hold off if you can. You can get me the incident report for 2011. Are you saying if you can get me the incident report during stream, Guns Beer Freedom? If you can get it to me during stream, that'd be interesting. Yeah, I do have the petition for driver's license restoration. That's this 2016 document here. I cannot do a Bill Burr and I cannot do a Columbo, guys. Those are ones I would have to listen to recently, and I have not done. I need to slur more in the verses of Landui when describing what he does. All right, Guns Beer Freedom. I can, if you can get me that incident report, I can cover this in John Cena. I got your incident report for 2018. Sneak peek, he doesn't make it to New York for the physical delivery. Wait a minute. Is that a real thing, David Wadding? If that's a real thing, I might die on the stream. Who is Charlie Kelly? All right. Let's oh, sorry. Man, that would have been really funny. Oh, that was Hibiki. Hibiki is very good, but I forgot I poured it. Do Adam West. Oh man. Oh guys, I've got to get Charlie Kelly is a famous bird lawyer. Oh, okay. Sorry. You guys the liquor is starting to hit. Let's go through this. Cuz this is funny in my opinion. In my legal opinion, this is funny to Pikachu. Pika. I can't get high enough for Pikachu right now. Pika. Oh goodness. So this is his 2016 petition for the reinstatement. This is actually not the petition. Let me see if I have the actual petition pulled up. Let's see, 2016. Oh, 2014. Sorry. Here's the petition. So this is a petition for driver's license restoration. So let's go through that real quick. No, I have not actually studied bird law. I've not actually studied bird law. But Eric Cartman. I can do an Eric Cartman, I guess.
Hey guys, seriously. Now comes the above-named petitioner Kevin Aaron Landau, and shows under this honorable court as follows. That your petitioner resides at... doxed. 980 James K. Boulevard in the city of Pontiac, county of Oakland, and state of Michigan, driver's license number L530-465028696. That on June 8th, 2014, your petitioner's driving privileges were revoked by the order of the Secretary of State for the state of Michigan from June 9th, 2014 through indefinite.
Through indefinite. Guys. Oh, I'm sorry I had to break character. Guys, his driver's license is revoked through indefinite. Eternally a bike lawyer. Oh. Oh my gosh. I gotta through indefinite. Whoa. Gatscat says everyone needs to start donating. He's about to be sued. Yes, some horrific doxing has occurred by the court here. Eli Reeves. Do we know how Maddox even found Landau? Like, did he Google drunk lawyer or anything? Eli, let me go into something here, because I've been trying to figure this out. Landau, from what I can tell, has significant ties to Los Angeles. To the point where he used to own or co-own 2 stores in Los Angeles, which, from my understanding, have now have gone out of business. This was back in like 2011, right around the time of the drinking. So he was co-owner of a couple stores. I think one is called like Peasant. That one might be in Michigan. And then he had another one that was just P in quotes. Sorry. Okay, I'm drinking a lot if I'm laughing at the letter P, because it might be P. But one of them was called P, and then there's another one, I don't know, but it was in West Hollywood. So he has significant ties to Los Angeles. He also is currently representing someone, and this I will give him props for. He is representing a woman who appears to be an escort or a prostitute. I don't actually know that for sure, but that's kind of the implication. He is representing her against a Soros fund manager who allegedly hired her, brought her from California to New York, and rather brutally sexually assaulted her. And if that is a true case, and if he's not just lying, jumping onto a news story, then I commend him for representing her. I wish he would have gotten maybe more competent representation. But that guy is accused by several women of doing that. Gatscat says, ambulance chasers right. Landau is a train wreck chaser. That's how I found Maddox. Chris Griffith says, it's been stated in the past Jessica Blum's entire family is policemen and lawyers. And maybe Landau is that way associated with him. I think that Landau may be a fan. He is a contemporary age-wise of Maddox. He is 41 years old, I think, currently. And it is highly possible that Landau either is a fan of Maddox, is an acquaintance of Maddox, or is an acquaintance of someone Maddox knows. Do Leor's voice? Hold on one second. Our Muse says, so my ex-woman locked up for the 3rd domestic in 4 months' time with only a public defender. How effed is it? Dude, I mean, public defenders do good work, I will say, but they are overworked. And it's really hard. It's like a roll of the dice whether your case will get the necessary attention. So good luck to her, I guess. I don't know. Maybe you don't want good luck for her since it's your ex. But do the voice of the dude from YouTuber Law, Leor. I don't know if I can nail Leor's accent right now. Let me work on that one, Hat Buckles. But I will do. Maybe I could collaborate with Leor and get him to do an impression of me, and I'll do an impression of him. That sounds great. Do Winnie the Pooh. Okay. Oh gosh, Winnie the Pooh. Hold on. Let me see if I can do Putin. I can do Russian accent. Okay. Now comes above-named petitioner, Kevin Aaron Landau. I have already read this. That on June 8th, 2014, your petitioner's driving privileges were revoked by order of Secretary of State. Oh, man, I think I went out of Russian. Do Winnie the Putin. Do the voice of Nick if you want to get this done, buddy. Yeah, let's start moving through this. And YouTuber Law and I have talked. We have talked about doing a collaboration. It's just a matter of figuring out what and when. If you have suggestions on what we should cover, send them to me on Patreon or Facebook Messenger, and we'll figure that out. What exactly is it that makes Dog Bite Law its own category? Mekhet, Dog Bite Law is... It actually kind of can be its own category because very specific set of liability for dogs, and it matters because it matters if the person has a right to be where they are. It matters if the dog is provoked or not, and proving those facts can become in a metro area can become quite lucrative. For Bill Burr, all you have to do is a Boston accent. It sounds as French as surrender. Oh goodness. I will have to work on my Russian accent. I do quite a good one. You'll have to believe me. Hello, Borat. Hello. You did Boris, now do Natasha. Shrek. You two should cover the Brown versus Board of Education, obviously the lawsuit. I think Brown maybe deserves some work, but Brown is a really long case. Yeah, Clay, why are you turning into Tess? Best push it forward. Okay, let's go through this. This revocation was based on an occurrence on May 2nd, 2014. The first full day petitioner had the interlock ignition device in your vehicle. So guys, let me paint a mental picture. Let me paint a picture for you. So Landau drives drunk in 2011. And then after 3 years, he gets an interlock ignition device on his vehicle because after his second DUI in 2011, which he gets convicted of, let's see, he's found guilty on May 24th, 2012. He's found guilty. He does not plead guilty. Yeah, seriously, Guns Beer Freedom. He says, my apology for not having the 2011 documents on hand. You have been lazy. How dare you? Don't worry about it, pal. You've given me more than enough so far. So the incident is 3/25/2011. He is found guilty at trial on 5/24/2012. He is sentenced to 18 months probation, 95 days in jail, and $2,370 in a fine. I don't know how much of that time was actually served by him. I don't know if he got credit for time served because this is unclear from the record that I have, but he may have served approximately 35 days in jail. So he may have only had to serve 60. He may have had part of that sentence stayed. I just don't know. But so I don't want to say he served a lot of time in jail, but he could have served up to 95 days in jail, or probably 2/3 of that if he was good and did some community service. But okay, so once he's found guilty, his license is revoked. Sometime around then. So Guns Beer Freedom says he served 93 days. It took me the whole stream to realize it, but your original Landad voice was a spot on Grunkle Stan from Gravity Falls. Okay. I haven't watched that. I should watch it. So he served 93 days in jail. Then his license is revoked. And then in 2014, he is petitioning to he petitions to have his license reinstated, and he is granted limited driving rights. Okay, so this is important. He does have his license partially reinstated. The condition being he has an interlock ignition device, which, if you're not familiar, means that when you go to start your car, you have to blow into a breathalyzer to start your car. And then they also have this thing called a rolling retest, where while you're driving your car at random, it may require you to blow into it again to keep the car going, because the possibility is that you might have someone else blow into the breathalyzer to start driving drunk, and then they don't want that to be the sole thing. So you'll randomly be retested while driving, and the idea is that it's less likely that you'll have the same person who lied for you the first time blow into the device again. So this is what happened. So the revocation was based on an occurrence on May 2nd, 2014. The first full day petitioner had the interlock ignition device in his vehicle. So he has the interlock ignition device for one whole day and fails. Gadscat says, everyone that wants 2 more hours type kill that liver. Okay. Yeah, David Waiting says you can get your license back after it gets revoked if you use your CDL, which is way more qualified beyond you plebs. If you F up once, it's gone forever. Yeah, CDLs are high standard. You can't have a DUI with a CDL. No, it takes your picture. He blew sober and then drank on the road. Very possible. Very possible that he blew sober and then drank on the road. Oh, it takes your picture. I see what you're saying. The interlock ignition also takes a picture of you blowing. So what Hatbuckles is alleging here is that Landau blew sober initially because it takes your picture when you blow into the interlock ignition. I don't know. Did they do that in 2014? I'm not familiar. I don't drive drunk. He blew sober and then drank on the road. So he's saying that he drank after he initially blew sober. So here we go. So his first full day of having the device, he fails. He fails a test, a rolling retest. So that's right here. A rolling retest. Oh, let me zoom this in. I don't know why this is zoomed out. Dax Desi says Landau should just become sovereign like me. We don't create joinder with the state. The police have no right to ask you for your license. I fully agree. I want video of Landau doing sovereign citizen arguments. Man, that'd be funny. I might pay him for him. So, a rolling retest violation was recorded on said date for the following reasons as indicated on the interlock device's computer generated report. Abort sucking, abort humming. Never abort sucking and never abort humming. A copy of the report is attached here too and marked Exhibit B. So here's the argument, guys. Here's the argument. This is Landau's attorneys writing this. And in this case, this is Arthur Landau. So this is his dad. Because earlier in the case, Landau does have a different attorney than his dad. Petitioner suffers from chronic asthma, but remains fully compliant with all of his previously imposed conditions. Petitioner's asthmatic condition made the blowing requirements for this device very difficult. Notice, so here's the fun part of this. Here's the fun part of this. Landau is allegedly asthmatic, but it was not raised in either of the two cases that the breathalyzers that he took, either the field test or the intoxilyzer at the police station, were failures due to his asthmatic condition. So that's a little interesting to suddenly claim that he is asthmatic. Now, maybe he developed asthma later. It's possible that he developed asthma in the interim, but I doubt it. It was his first day with the interlock. Yeah, he thought he was going to get away with drinking on the road. What a chump. Yeah, I agree. This just reeks of that type of thing. Phelan Miller, thank you for the donation, buddy. I really appreciate it. But yeah, this just reeks of him thinking he could maybe beat the system. Maybe he did something like there's rumors that if you put like a copper penny under your tongue when you blow into the machine, that it will register that you're not drunk. Those sorts of, I would not place my faith in those sorts of gimmicks. Maybe he thought something like that would happen. So anyway, petitioner requested additional instruction for, okay, so sorry, I skipped ahead. So petitioner's asthmatic condition made the blowing requirements for this device very difficult. Letter from petitioner's physician and medical professionals are attached here to and collectively marked Exhibit C. Gatscat says, let's be real. Landui has never had a problem blowing. From the evidence that we have, he has no problems blowing into these devices at all. I will fully agree with you. On May 2nd, 2014, petitioner was experiencing difficulty in mastering the device's blowing requirements. Sometimes lawyers need to be punched in the mouth for how they say things. And immediately returned to the vendor's location where the device was installed the previous day, because his liquor consumption was apparently the problem of the device installation. Petitioner requested additional instruction from the technician, who presumably told him, dude, bro, please stop drinking and driving, and has been without incidents ever since. A copy of the letter verifying petitioner's return to the vendor's office is attached here to and marked Exhibit D. Pony Cordero says, according to maritime international space law, you cannot infringe on my rights as an individual sovereignty as a sapient entity in time and space. So number 7, this violation was merely a result of either the device's internal malfunction, because on the first day it's likely to have a malfunction, or the mechanical difficulties associated with a brand new piece of equipment. Mind you, guys, Kevin Landau has a doctorate of law. He's a Juris Doctor. This is one of the, probably top 20% of educated people in this country. He's having difficulty mastering the straw that you blow into. When your argument is, I'm an idiot, maybe you should not make the argument. So petitioner prays that an order be entered requiring respondent, Secretary of State for the state of Michigan, to appear before this honorable court to show cause, if any, they may have, why the revocation of petitioner's suspension of petitioner's driving privileges should not be set aside. Maybe because he failed a interlock ignition test. Gatscat says he needs lessons in blowing. Maddox's beautiful model girlfriend's boyfriend can teach him. Ooh. And Fred Rush MD says he's used to sucking on straws, to be fair. And I think so. Like, if you're having certain cocktails are drank with a straw. Drunk? That an order be entered restoring petitioner's driver's license on a restricted basis in the same manner as previously provided by the respondent. Spoiler alert, the court does not accept this argument. Okay. So this is filed by the Secretary of State, and this is filed... When is this? December 9th, 2016. Oh my goodness. Counter statement of facts. This is interesting, and I do want to go through this document real quick. Because it's kind of It's kind of important. This is what the Secretary of State says. Petitioner's license was revoked in June 2012 because he had 2 or more substance abuse convictions in 7 years. Can't do that. Oh, and by the way, dragging out that first case, let's see, may have actually hurt him. Oh, no, he's still convicted within 7 years. Never mind. That didn't hurt him. He had 2 or more substance abuse convictions in 7 years. See petitioner's driving record at Exhibit A. Oh, do we have Exhibit A? We do. Oh, they don't actually provide it. Rats. That's too bad. At Clay, I recommend everybody send you nudes. I do this all the time. You pay me for it. But, okay. On April 25th, 2016, petitioner attended a driver assessment and appeal division hearing before hearing officer Diane Odrobina. Petitioner's request for any driving privileges was denied. So, still denied. See April 29th, DAAD, order at Exhibit B. Petitioner now appeals to this court. Argument. Yes, my advice is that everyone send Clay nudes. David Wading says, Nikki Raggets, I have a question. Are you aware of state dependent memory? Are you only a law once whiskey exists? No, I am typically not inebriated while performing actual legal functions. So I'm not only a law when this exists. Hatbuckle says, to be fair, when I worked for attorneys, I never had to pay a ticket because I had a template motion for continuance and filed it until it was denied. Worked every time. Yeah. That could be a good strategy. Argument. Petitioner's driver's license was initially revoked because he was convicted of 2 or more substance abuses within a 7-year period. At the time petitioner's last arrest, the statute provided this. I'm not going to read through it. It says that if you're convicted twice in 7 years, screwed. Peach, don't listen to Clay. So, pursuant to the statute, petitioner must prove by a preponderance of the evidence that the reinstatement of revocation of driving privileges was without sufficient cause or reason pursuant to 2011 MR3 Rule 257.313A 11C. Gatscat says petitioner had pennies in his mouth and therefore couldn't have blown over. I don't want to offer conjecture, but I conjecture the machine was broken. Yeah, FSP AMSS FSPAMS. That's the master plan. Yeah, I'm clearly too intoxicated to serve in capacity of a lawyer. All right. At the most recent hearing, petitioner testified that the last date of consumption of alcohol was May 26, 2011. Red flag lying alert. Here we go. As this was a show cause hearing, the hearing officer's main questioning to petitioner involved several positive alcohol readings captured on the interlock device during the time frame when restricted driving privileges were granted. Several positive alcohol readings. The man has a problem. Get him help. To all of the readings, petitioner was adamant that they were not caused by alcohol use, rather possibly from use of a steroid inhaler followed by the use of Listerine mouthwash to clear the residue left from the inhaler. Buddy, gargle water. Gargle water. But to the hearing officer, such use of Listerine mouthwash, despite petitioner's need to prevent gingivitis...
Gingivitis.
Who remembers the gingivitis commercials, man? Those are great. Was not acceptable behavior for someone that, quote, had been given explicit instructions to not use such a mouthwash in an earlier order when restricted driving privileges were granted. So yet again, his defense is, I'm a giant idiot. The hearing officer went to great lengths in her current order at Exhibit B to highlight the portions of her earlier order which explained when a preliminary breath test or an ethyl glucuronide test should be taken at each time a failed alcohol reading was recorded. Dax Desi says it's not his fault the pharmacist spiked his inhaler with ethanol. Though petitioner received several PBTs on or near the dates positive alcohol recordings occurred, in no instance was a PBT taken within the time frame that a PBT reading would be accurate to prove or disprove alcohol consumption. Yeah, Clay says as though non-alcoholic mouthwash doesn't exist. Right. Absolutely. Guys, this guy on several occasions blew positive alcohol tests. This guy has a problem with drunk driving, and we need to be aware of that. He appears to be a literal menace to society. Hatbuckles asks, is he saying he used mouthwash on the road because he used his inhaler on the road? It's reckless driving regardless of alcohol use. Gatscat says, I just noticed the downvotes. Can you at least start these streams with a shout out to Maddox and his beautiful model girlfriend? Kill that liver. So this guy has several failed tests. And each failed test, he is supposed to go to a place where he can take a portable breathalyzer test to verify that he is not actually drunk. And he doesn't ever do it. Never. No instance was a PBT taken within the time frame that a PBT reading would be accurate to prove or disprove alcohol consumption. That is typically 2 hours, by the way. So every failed test, he's more than 2 hours away from a PB test. In no instance was an ETG test taken. In fact, petitioner, though he had received and read the order allowing restricted driving privileges, was unaware of what ETG test even was. So he didn't read his own order. Can you get a DUI riding a bike? I don't know. There actually might be, it wouldn't be a driving under the influence, but there may be some sort of biking while intoxicated charge in some states. I'll see if I can find that answer for you, buddy. To the hearing officer, such a lack of evidence could not lead her to conclude that petitioner's alcohol problem was truly under control. And it really doesn't look like it is, at least as far as December 2016. And Landau, if you're downvoting this, please get help. Further, she could no longer conclude that petitioner poses a low/minimal risk of repeating past behavior when he has done exactly that, attempted to operate his vehicle with blood alcohol content levels on multiple occasions. Multiple occasions. Therefore, the hearing officer denied petitioner's appeal and affirmed the revocation/denial of driving privileges. It is clear that if the order of the hearing officer is supported by competent material and substantial evidence on the whole record, it must be affirmed even if the court on appeal would have ruled differently had it been first reviewing the evidence. Kester versus Secretary of State. When agency determination is reviewed on the record, Court of Appeals has defined what constitutes substantial evidence. We're not going to go through this. Guys, are you really surprised he didn't read his own documents? I am. As a lawyer, I read all the documents. Master Deceiver, I've seen cops pull someone over for riding a bike drunk. Yeah, I think it's probably specific to the instance. If you're on a sidewalk or public road, there very likely is a problem with riding a bike drunk. I just don't know the statutes for sure. So I don't want to state unequivocally that it is. Tim, driving a bike drunk would likely fall under public intoxication provisions. That may be true. In Minnesota, there is no public intoxication provision. It is specifically not illegal to be intoxicated in public. Hatbuckle says a man was arrested for DUI while riding a motorized bar stool because it was motorized means of conveyance. Oh, man. All right, guys. So that's what I've got now. We're closing in on 3 hours. The liquor's hitting me kind of hard, and I think I might need to fall over in my bed pretty soon. Is it possible to put an interlocking breathalyzer on a bike? Yes, but all it does is it either adds or doesn't add the cards to the spokes, so your bike sounds like a sweet motorcycle. Gatscat says, as a good lawyer, I read all my documents. Fixed it for you, yeah. Fred Rush MD, can you explain what a habitual drunkard is in a legal context? I remember seeing that term on a form 4473. I would have to look into that, but I would think someone who is routinely picked up for intoxicated behavior or intoxication in public or intoxicated driving would probably fit that description, but I don't actually know. I'll have to look at form 4473 and try and find the definition for you. I just can't do it on the stream. Pony Cordero says it depends on the state definition of a vehicle. States like Washington, Ohio consider a bike a vehicle and treat it as a normal DUI. And I think that's, I think that's actually a good thing because you are likely to run into someone on a bike, right? You could run into, you could hurt yourself. You could hurt a child or another person. Clay says, don't listen to Peach. Also super chat drink. I don't know. What did Peach say? I missed it. Sean LaRocca says, if you weren't a lawyer, what would you be instead? Before being a lawyer, I worked in banking and finance. I don't know what I would be now because I live in a very small town. So probably like a retail sales associate of some sort. Hat Buckles, don't forget about Georgia v. Denver, Fenton Allen. Can you email that to me? Cause I'm going to forget from this stream. I apologize, but, the liquor is strong with this one. And, I've got more coming and I don't want to forget. So if you can please send that to me. To drink water, I will drink some water as soon as the stream is over. I also have sweet tea, even though it's from McDonald's. It will do in a pinch in Minnesota. I will properly hydrate. So anyway, guys, thank you so much. Thank you so much for joining me. Hat buckles, Rekieta Law at rekieta.org. If you could email me that or send it to me in some other messaging forum so I remember, I will gladly read through it and see if I can do a video on it at some point. I hope this has been informative and educational on how to lose a DUI case. Like I said, the first case, he ended up pleading guilty. The second case, he actually lost. And he lost badly, and he lost his driving privileges literally forever. Let that sink in. Guys, you're a grown man, and you can literally never drive again. Ever. Ever. All right. Thank you so much for the stream. I'm going to fade this one to black. If you have any last minute stuff, please drop it now, and I will see if I can address it. Otherwise, join me for the next stream. Hopefully, we'll have some lawsuit documents at the end of next week. I think Weber Shandwick's response, or Landau's response to Weber Shandwick is due on the 8th, I think. So we should be live streaming those documents. If the trademark stuff comes down soon, we'll probably live stream that. Also, I have some Google videos that are coming out. I do have a Black History Month video that is late. It is done mostly, but I want to add a little bit more to it. So I've got to finish that up. That'll be coming out soon. If you have content suggestions or requests, please talk to me somewhere. Patreon is a great way to do it. If you are a $5 plus Patreon, you get to help dictate the content specifically. So please do so. I would love to have you guys tell me what to make. And Kenster says, I was planning on sending you a New York City penal law book, and I apologize. I saw this earlier, but I did not read it. Yeah, you can send that to me. Absolutely. I would gladly look at it. Gats asks, do you think it's possible that Maddox is paying Landui with Jessica Blum, the beautiful, totally real model? Possible, yes. It would be a violation of Landau's ethical obligations. You're not typically allowed to have sexual relations with any sort of client unless they are your spouse or related to you in some sort of way. But even if there is consent involved, that is typically not allowed. Ashley Princess says, one last drink, chat. I will drink to that. Tim, good job using privacy on your domain. Whoever handles your website /IT gets a thumbs up from me. I'm not exactly sure what you mean. You mean rekietalaw.com or .org or rekieta.org? I don't know. Pony Cordero, thanks for the laughs. Here's a tip. Thank you, buddy. I really appreciate it. Hatbuckles, another YouTuber, Styx Hexenhammer, did a very interesting deep dive into the Charles Manson case. Any interest in something like that? I'm interested in whatever you guys are interested in. If you think it's interesting, please send it to me and I will work towards it. Eric Blum says only incest. Thomas says true last drink chat. You guys can fight over the last drink chats all day. Master Deceiver, thanks for the stream. Made my week. Mine too. How else would they be related to you? I don't know. I don't remember the specific professional responsibility rule, what exceptions are allowed, but generally don't sleep with your clients unless you're married to them. But that might include, okay, so that real talk, it might include a significant other who at the time that the rules were written, prior to a lot of gay marriage being passed in the States, might have included a life partner. So that might be it. I don't know off the top of my head. Sovereign Citizen Movement is the only thing. That reminds me, Dax Desi, thank you for reminding me. I will be doing a Sovereign Citizen live stream where I will watch and display live a Sovereign Citizen video, and I will talk about the legal issues with what they are talking about while drinking. That should be fun. Sean, thanks for joining me on the stream. Gats, maybe he was just using mouthwash instead of reading his ethics books. Red Wolf, he means he can't get your home address from the websites. Who is data? Clay Early, my dude, couldn't get me any crosswords tonight. Can I sue him? Yes, absolutely. If you want to send me something, send it to my, I see what you're saying. But yeah, if you want to send something, send it to my office address, which is on my Rekieta Law Facebook page. Anyway, I'm going to go to blank. Thank you guys so much. You guys make it really worth doing all this stuff. I have a ton of fun doing it. As long as it's entertaining for you. And if it's not entertaining for you, if you have a problem with this, please let me know. I love taking constructive criticism and making a better and better product. My goal is to add more viewers and to entertain more people. So thanks a bunch. I'm rambling. Too much drink. Talk to you later.